Heyo, folks. Ooh, if you haven't heard, today in the Young Thug trial, all hell broke loose. Whatever you think you've ever heard about what has happened in a trial, this has, I can almost bet you good money, what happened today has never happened in a US court the way it happened. Do I wish I was live when it happened? Well, yes, of course. But nothing in this trial. So up until I assumed Woody would be there in the morning, pleading the fifth, or just stalling. Instead, we had what was it? A 3-hour late start. I saw on other sources that, they are having a separate hearing in front of another judge regarding plea deals. I even did a video on it. And no, it wasn't. It certainly wasn't. But let's start with the knowledge we have now about the absolute fuster clock with Woody taking the stand 3 hours late. Oh, and I need to say this. I've been listening to the trial in the background, so I heard the trolling going on from Woody. But the moment I heard, Mr. Steele is on the attack, I paused. Now, I do know what happened through Twitter and other things, but I haven't heard what was actually said. Or the faces or the reactions, I haven't. So this will be as raw of a reaction from me as anything, as possibly can. But we have to start from the beginning today. Knowing what we know now, seeing Woody's smugness on the stand. I will play this in 1.25 because there really is no need to go slow.
Thank you, Sir Copeland here. So go ahead, Ms. Hilton.
Thank you, Your Mr. Copeland, good afternoon. Good afternoon.
I got to say back.
You understand me that? On Friday when we left, I asked you how old you are. You said you were wrong. Can you please tell me how old you are?
Say that again.
Sure. Can you please tell the jury how old you are in numbers?
32.
And when's your birthday?
Say that again.
When is your birthday? I'm sorry. When is your birthday?
This month.
Is that July?
Okay.
I think so.
Okay. And
Prosecution
we're
is
on July
handed the
25th.
microphone.
I guess.
Are you from Atlanta?
I'm from Candyville.
Okay. Is that a section of the city in Atlanta?
I guess.
You guess? All right. And did you grow up in Mechanicsville?
For sure.
Did you say for sure? All right. And when you grew up, do you have siblings?
Huh?
Do you have brothers and sisters?
Yeah.
All right. And when you were younger, did you live with all your brothers and sisters?
Objection, relevance. Overruled, sir.
Yeah.
Okay. I want to specifically talk about your brothers. How many brothers do you have?
Relevance. Overruled, sir.
More than one.
Okay. How many?
I think 3.
All right. And what are your 3 brothers' names?
Relevance. Overruled, sir.
Trey Nato Boss.
Say that one more time. You said it fast.
Nato, Trey's boss.
Nato, Trez, and Boss. Okay. Nato, what's Nato's given name? You just give me the first name.
I just did.
Nato?
Yeah.
Okay. Trez, what's Trez's first name?
Trey's.
Is Trez's first name Ron Trez?
I guess.
All right. And Nato, is that Rodney?
I guess.
Okay. And then what's the third nickname you gave me?
Boss.
Is Boss Rodriguez?
I guess.
All right. And when you were younger, did you go to school?
Yes.
Where did you attend school?
I don't know. I went to a lot of different schools.
Okay. What are all the schools you went to?
I don't recall all of them.
Or just tell me some of them.
I only know one. Slater.
Slater. Is that elementary school or middle school?
Elementary.
Why you don't remember what middle school you went to? Did you go to middle school?
I think I did.
How long did you go to? Did you finish middle school?
Relevance.
Overruled.
Yeah, I think.
Okay. Did you go to high school at all?
Now, when I listened to this earlier today, I thought he was just trolling because he could. Knowing now what happened in chambers, ex parte with the prosecution and the judge. And remember, the judge, when he started today's trial, not a mention to anybody about an ex parte meeting with a sworn-in witness who was blackmailed on the stand through an immunity agreement, and nobody told the defense until later. So his smugness has so many more levels with that information.
Yeah.
All right. When you went to high school, did you go to Southside?
Yeah.
Yeah.
Overruled, sir.
Did you graduate from high school?
No.
All right. Do you remember what year you left high school?
No.
After high school, did you work?
No.
What did you do after high school if you weren't working?
Say that again.
Did you do anything? If you weren't working, what were you doing?
I don't recall.
Okay. Are you married?
Nope.
Are you in a relationship?
Nope.
Do you have children?
You know that.
I do, but the jury doesn't. Do you have children?
Yep.
All right. How many?
More than one.
All right. You have more than 3?
I might. Ain't no telling.
Okay. That's perfect. That's fair. Do you have 2 that you know of?
Yeah.
All right. And how old are your 2 children?
The same age.
What's that?
I don't know. Y'all been having me in jail so
Yeah,
long.
I
can't
know
recall.
the judge
Were
always
you in jail on
blames the
Friday?
defense for the delays in this trial.
Prior to?
Yeah, I was
But-
in jail Friday.
Were you in jail on Thursday?
I say this, and I've said it more than once. This trial was supposed to take 6 months in total. We are now over 7 months in, apparently. Let's see here. November 28, December 28, January, February, March, April, May. Well, 6.5 months, whatever it is. And we are not even close to finishing the prosecution's case in chief, because they bring on the absolute worst witnesses. You have corrupt cops admitting on the stand that they destroy evidence. The prosecution has lied to the court on dozens of times without getting into trouble. And now we have definite proof that the judge is coercing with the prosecution. Definite evidence. We will get there.
Thursday came yet.
No, last Thursday.
I felt like it.
All right. When you weren't in jail last Thursday, although you felt like it, how old were your children?
I don't know their ages.
Are you currently working?
I'm in jail.
Prior to going to jail on Friday, are you currently working?
Nope.
All right. Now, you talked about being in jail, which was on Friday. Prior to any of this, do you have any criminal convictions?
Of course.
Okay. Do you know offhand how many?
Don't keep up with it.
Yeah, it doesn't keep up with it.
Tell the jurors the types of crimes that you've been convicted of.
Yeah, and he goes on, and now he keeps trolling the prosecution because he knows he can. Because so he has. Remember, the prosecution gave him immunity. Now, this immunity is only for this county. So he has to testify. He doesn't have Fifth Amendment rights anymore because they gave him a piece of paper that says, we will not prosecute you for what you say on the stand in Fulton County. But now he has a secret. Or to be fair, he told Judge Glanville and Prosecutor Hilton a secret in chambers. And he knows it, so he trolls them. And well, he now he has to. The prosecution has to. Is this what you've been convicted of? Is this what you've been convicted of? Over and over and over again. So we can skip past a bit of this. And the judge have a cold. I hope it's COVID. You fuck twat. Sorry, folks. I said 4 quad and nothing else. YouTube's. It's my accent. It makes words come out differently. I said 4 quad and nothing else. Now they are admitting evidence.
To states 392 Yankee, 383 Yankee, 384 Yankee, 380.
And we have a sidebar, which brings us to sidebar counter 201. Let's get past that one.
And Rice Street. Did you get out of the federal custody in 2021?
I got it fixed in 2019.
Okay, thank you. Now, Ms. Coleman, do you have a nickname? You're smiling. Do you have
Ask me a question?
Do you have a nickname?
Yeah.
What's your nickname?
Psycho.
Okay. Do you have another one?
Yeah.
What's that?
Woody.
Woody. And do you have a way that you spell Woody?
However people want to spell it.
Okay. And how did you get your nickname?
My mama.
And when people refer to you, do they refer to you as Kenneth, Psycho, or Woody?
All 3.
All 3. Which one do they use the most?
Relevance.
Your-
Overrule, sir. That's not objection, sir.
Which one do people?
Overrule, sir. He said speculation. Overrule, sir.
People who don't know me that good call me Woody.
And what about people who know you?
They call me Kenneth.
They call you Kenneth. Now I want to ask you if you know a few people, all right? First, do you know someone by the name of Shannon Stillwell?
What's his nickname?
SB or Shannon?
Oh, this is good. Now now the prosecution is making him
Or Shannon
point out
Jackson.
Shannon Stillwell.
Shannon Stillwell or Shannon Jackson. Same
And
person.
remember, it's the state's case that Shannon Stillwell committed the act against Donovan Thomas. This will be important later.
Yeah.
Okay. How long have you known Shannon?
We went to school together.
Do you remember which school?
I know one of them.
It was one of them. Was it elementary or middle?
Might be elementary or middle.
Okay, I've been told here you might want to go live and come back after. Okay, let's do that. Well, let's skip ahead to what happens after the lunch break. Because here is the main course. Attorney Steele finds out. Okay, no, they are recess. Okay. Well, it's no longer that important what happened in the testimony of Woody, because it really isn't important anymore. Let's move on to the main course of this recap. Attorney Steele, during the break, finds out about the ex parte meeting between Woody's attorney, the judge, and prosecutor Hilton. And not only that, he has found out what was said in that meeting, despite Judge Glanville putting what you call it, protective order on it, that nobody in this room is supposed to reveal it. I'm going to play this.
Thank you.
Go ahead.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness. And that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never.
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
This is the judge's concern. He's not concerned about what happened in it. He's concerned who told you. Now, there is not a lawyer worth its name who will ever reveal the sources to this kind of information. And yeah, judge isn't denying what is transpiring right now. He is just mad somebody told.
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438. It's the.
Yeah. Mr. Steele now cites statutes that actually says he does not have to reveal, I believe.
Division 2, 782 Southeast 2D 638 2016.
It's about here when I
our highest court says
together.
when the court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me. It's those were ex parte for a lot of different other reasons, but I will
Judge.
certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
And you haven't answered my question yet.
I'm not
how
going to
did
answer
you-
that question.
You're not.
No, I will not answer that
Why
question.
will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to
No,
get
no, no,
anybody
no.
else.
I'm
into
asking you,
any-
how did you get this
I'm
information?
not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now. and
Okay,
I'd like to
I know.
continue.
Look,
Now, Judge Glanville is starting with the threats, which will become a reality. For me, this, if you ever doubted me saying that that Judge Glanville is as much part of the prosecution's team as Miss Love, Miss Hilton, and any of the others, I don't care enough to learn their names. This is it. This is the ultimate evidence that Judge Glanville is a part of the prosecution's team. And I'm not even saying in my opinion. I will say it right out loud. My only wish is that this would have happened August 14th when I am in Atlanta and was planning to attend this courtroom.
I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
A party,
yes.
a witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court
Mr. Steele,
handed
ask
Mr.
me,
Copeland.
tell me how you
perjury.
got the information.
Listen, whatever you want to do.
Tell me
I'm
how
not
you
telling
got the information, then we can go ahead and go forward.
I'm not going to say that.
Judge Glanville, you vindictive piece of human garbage. You know what you did in there, and withholding this exculpatory information from the defense should render you thrown out from anything that has to do with law from now until forever. Copeland was sworn in as a witness against the defendants. Everything that happens to him, the defense has an absolute right to know about.
What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
Information that you
Proprietary?
should not be having that
hell
was
no.
ex parte
Why?
with a party,
Why?
state of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court,
Okay.
or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele,
I'm
I
doing
still
what
want to
everybody
know,
should
how
do.
did you come upon this information? Who told you?
What I want to know.
The judge isn't denying the information. He's just mad that somebody found out that he is as corrupt as an Islamic State prosecutor, as an Islamic State judge, as a communist judge. This is corruption because Judge Glanville is the chief judge in Fulton County. Nobody controls him there. There has to be a higher court who puts down the hammer on him. And he knows it. He believes he is safe. That is why he is doing this.
Oh, is why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this information
don't
was
want to
coming
be
from.
held in contempt.
Well,
I'm not
then-
answering that question. That's attorney-client privilege information. I am not answering that
Attorney-client privilege, unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you what, I'm going to give you 5 minutes. If you don't tell me
You don't
who
have to.
if you don't tell me who it is, I'm going to put you in,
Well, let me-
I'm going to put you in contempt
I
because
understand.
And what the judge is doing now is desperately trying to avoid this being read into the record. That is what he's doing right now. He don't want this on the record. He doesn't want it to be told to the world. Too late. Yep.
That is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information
I go to
supposedly
answer
from
that
my
question.
chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes.
This is what I was told. Mr. Copeland,
recess.
Mr. Copeland made
recess.
statements that he admitted to killing.
Judge Glanville, the absolute coward, runs because he knows he fucked up royally. He knows how bad this is. He knows. And that is why he's running. That is why he's desperately calling the court is in recess, because that ends the court record. No matter what Mr. Steele is saying now, boom, sorry, they were in recess, not a part of the record. It's a part of the public record, though. We know this. That Judge Glanville is a spineless coward who should never again enter a court of law unless he's prosecuted.
Donovan Thomas and was. Don't take my notes. No.
You heard that? But this is from witnesses from within the courtroom as well, that the court officer walked up and tried to take Mr. Steele's notes. What happened just here is a unicorn of trials. This never happens. Why? Because even the most foul judges knows to not do this. This is the epitome of corruption of the justice system. Not only did coward Judge Glanville run away in a desperate attempt to not get this information out, court officers tried to steal Mr. Steele's notes to find out who told him. And they went on a break. Let's skip ahead.
All right. Do we have everybody with you? Sergeant?
Yes, sir. Everybody's present.
Okay, Mr. Steele, would you take the podium, please, sir? All right.
For you out there,
All right.
clip everything I
Mr. Steele,
say
before
about
I
Judge Glanville
recessed,
in this and show it to the world.
I asked
want
you,
the
how
world
did
to
you
know
get this information?
how much I despise this poor excuse of a lawyer. He is a disgrace for his position. That robe and that chair, that deserves recognition. That deserves respect. Judge Glanville corrupts that seat and that cloak. As I said earlier, unless he's being brought in as a defendant, he should never be allowed near a courtroom ever again.
And it is not covered by work product. There's only one way you could have.
That's no longer up to you, Judge, because The allegation is against you. You cannot be the decider in the corruption of yourself, in my opinion.
Gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know
Lies.
I know what the rule says, but here's the thing.
Well, let me just.
Again, he refuses to make Mr. Steele put things on the record. Why? Because not having it on the record means it will be harder to put him forward into the Court of Appeals.
But in order,
Interrupt.
you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in.
What is sacrosanct is you withholding exculpatory evidence from the defense. Woody admitted to killing Donovan Thomas, aka Nut, in chambers. You withheld that information from the defense. You never expected this to come out. You would have held this a secret indefinitely. You would have sealed that record, even from appeal. This is pure corruption. This isn't even kangaroo court anymore. This is former Eastern European court, where everything was held in secret, and you were convicted and barely found out the charges or the evidence against you. This is what's going on in Fulton County Court today.
My chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte.
Hey, how would they ever have known that they should have been in there if you never told them that they had? You let Woody take the stand, knowing he just admitted to you that he was the culprit in the Donovan Thomas murder. You plan to keep this a secret indefinitely. You were planning all along to have this trial run its course, help the jury convict the defendants, and then pray it would hold up in appellate court. That was your goal all along, Judge Glanville, because you are as much a part of the prosecution's team as any of the morons sitting there, the soulless morons doing this.
The conversations are recorded.
Why would it be ex parte? You're
For
acting like
whatever-
it's ex parte under
It's
seal.
ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
Now, Judge Glanville can't run out again, so now he's running out mentally. He's trying to, but this, but that. As Mr. Steele said, he has never asked for an ex parte with a sworn-in witness or a witness.
The issue is, how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, That's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you. You're saying,
see,
you're threatening me with
the
contempt.
privilege
Just listen
would
to it.
occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you, I can't do that under the bar rule.
All right. Well, I'm going to hold you in contempt, and you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can.
No, he can't, Judge. Just because you want it, you can't just throw a temper tantrum and ask for it. Just because you claim, oh, that's not how I understand the rule, it's not up to you, Judge. You can claim it, but it's not up to you. That's between Attorney Steele and the State Bar. And Mr. Steele will not risk it. But he actually now puts his State Bar on the line, even by not answering the questions. This is the line in the sand for between Judge Glanville and Attorney Steele. And remember, Attorney Steele has won against this judge before. Appeals and ethical matters. So this judge is in a disadvantage because Mr. Attorney Steele is this good. He is this good. He probably knows the law better than this judge.
And because I have an idea how you got it.
Well, your idea.
I have an
may be
idea how
wrong.
you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not
Sir,
going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, you listen, and listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
From whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well then you'll be in custody until then, because because you need to tell me how you got the information.
The judge really don't want this read into the record. He really doesn't. He is prepared to throw everybody in jail to avoid getting this information, because it's not only that Woody confessed. It is that the judge and the prosecutor coerced together to make him not plead the fifth. Together, as a team.
I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably.
Now the judge is alleging that it is Woody's attorney who gave him this information. Now here's the thing. She has attorney-client privilege. Unless Woody gave her permission. Now, even if there is, I need a US-based lawyer for this, but it is my understanding that she also may have an ethical obligation to share information to the defense if she believes that the court is making a criminal act. In this case, coercion of her client. She has an ethical obligation to report that. It might be to the state bar with Mr. Steele CC'd, but she has an ethical obligation, if I read the rules right, to report this. And she probably, if she should have, and probably already have, reported this to the state bar with the information included.
You violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have a.
When I got this information.
I'm not going to have any further conversation
Well-
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's
All right.
really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your I'm going to deny your
Becoming-
motion. I'm going to deny your motion.
I
for
understand that
mistrial.
you spoke with a
And when-
witness outside of our presence.
And whenever, yes, I had an ex parte conversation,
And-
which is
and you-
appropriate.
And you influenced the witness based on information
Oh.
belief, and I'd like to have that all in the record.
All right.
I mean, I don't know why that's so hard to do. If nothing
Okay.
happened bad, that's fine. But you're
All right.
acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
Why
that's for
did we
another day.
exclude in the first place? I didn't know about this stuff.
That's
I raised
for
it
another
before the
day.
court.
So
I raised it.
Here's the thing. Judge says here that's a different for another day. No, it isn't, because the moment Mr. Steele learned, he has an ethical obligation towards his client to make this known to the court. There's no way around this, Judge Glanville. You fucked up royally, and now you're trying to save yourself.
As soon as we found out about it,
well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic
Steele,
reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele,
private.
that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been
Right.
sworn. You know that I'm not telling you. I'm just saying if you read the case, I'm assuming.
Yeah. It's Trinton P.S. I hope you hit the fact that because the judge and the state admit he saw it, that means he would have exculpatory evidence. Yeah, absolutely correct. The judge and the prosecution coerced together to influence this witness to not plead the fifth. And it's really serious because the more or less the coercion are against all the defendants, even those who pled, and against the people who are severed from this, who are awaiting separate trials. And finally, the confession from Woody is exculpatory because the state's case is that Stilwell committed this act. And if the prosecution and the judge has information that says otherwise, they have an absolute the defense has an absolute right to find out immediately, in my opinion.
When you read it, that's what it says. And you did it
The
supposedly.
state wishes to be heard.
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is
State
why
judge.
did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind. Yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because
what
unless
I
you're
got-
sitting there, you're eavesdropping. So you can't use something.
The judge is admitting on the record that the information is correct. Woody confessed. The prosecution and the judge coerced to get Woody to testify. This is unheard of, what Judge Glanville is doing. And he's the chief judge. He believes he's safe. Judges' immunity and all of that. Only a higher court can and should be the people who are hearing this part and make a decision. In my opinion, this trial should be on hold until the Georgia Supreme Court hears this.
Ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't.
The judge claims the defense have no business knowing what was said in that court, in that ex parte meeting. The judge is claiming neither the prosecution nor him has an obligation to reveal exculpatory evidence to the defense. That is, in my opinion, clearly unconstitutional on a federal level and on a state level. Not revealing exculpatory evidence to the defense is, as Mr. Steele said, that's an automatic reversal.
Give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
I'll
entitled to the-
that needs to be told. But
right now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
and I want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right on the
Just stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1, paragraph
you've
4
already said that. You've already
of the
said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, madam, Ms. Lowe.
It's the woman without soul who is entering the podium. The woman or person who loves seeing people die in jail because she makes the decision to put them there. I'm not surprised, sadly, about any of this. I am not surprised in the slightest that the judge and the prosecution is prepared to go to this level in order to get a conviction out of this trial. Ms. Love, she loves watching people die in jail and in prison. That's her favorite pastime, is knowing that her decision kills people. It's her absolute favorite pastime.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer
Oh,
from
gosh,
Ms.
okay, excuse me.
Okay. All right. Yes, ma'am.
Your Honor, I am disturbed by Mr. Steele's representations to the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was.
She is disturbed that somebody disclosed the information. Of course you are, Miss Love. You thought you had everybody in the grasp of your vulture claws, and it turns out you haven't. Somebody revealed your absolute corruption, your coercion together with the judge. Of course you're disturbed by it.
Was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state.
The state requested an ex parte meeting with the judge because Woody would be pleading the fifth today. So they requested an ex parte meeting with the judge so they could coerce together in order to get Woody to testify. They got more. They got Woody confessing to the murder of Donovan Thomas. And they couldn't have that. So they tried to seal this indefinitely.
To be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot.
Hello, Just Cause. Says held him in contempt for not testifying. That's unconstitutional. I would agree. But in Georgia, the prosecutor can show up with a piece of paper. We will give you immunity. And that completely erases the Fifth Amendment, apparently. Now, that piece of paper that says immunity is only valid for county and maybe state crimes, but not federal crimes. And if, hypothetically, she asks him a question as in, who gave you the drugs? Hypothetically. And he says a name. And the feds know, well, he took that from out of state. Boom, now there's a federal case, which they coerced him into testifying about by holding him in contempt because of that piece of paper saying immunity.
Make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the part.
Oh, look, it's the Satan's whore is now telling the court, oh, it's the defense who is making all these dumb things. Oh, we are the innocent. No, Satan's whore and Judge Coward, you are the reason this clusterfuck of a trial even is ongoing. Nobody else's. The defense is only doing their job.
Of a number of people that
I guess
not
I'm
comfortable
I can kiss
stating
any monetization
publicly
goodbye of this.
at this time, but
stream.
that
So super chat,
would appear to
give
call for being
membership,
addressed
become a member.
in some other way.
$3 a month.
So as
So I
to
get something out
Mr.
of it.
Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that.
Oh, stricken from the record in order to hide it from the appellate court. Isn't that convenient?
He obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6.
Your interpretation of Rule 1.6, Satan's whore, I don't care one bit about.
Standing there, 1.6 in no way shields Mr. Steele's answer that the court requested he give.
I know.
Rule 1.6 has to do
I had
with
work. I was listening
attorney-client
to this in the
privilege.
background.
And that is
I had no
information that
possibility
Mr.
to
Steele
go,
obtained from his
live
client regarding
until when I
whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6.
That's not up to you.
The court
That's
would
up
allow
to
me a
the
moment.
state bar. Not up to you, not up to the judge. It's up to the state bar. And I would assume
Regarding
that any defense organization, defense attorney organization in Georgia is up in arms at this very moment. They will not sit still about this. They will not be silent about this.
regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this.
I have not enough fingers or toes to count the amount of times Miss Love have lied to the court. And now she stands there, Satan's whore, asking for remedies against Mr. Steele for revealing their corruption.
from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right. Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained
Okay.
from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay, yeah, he does, but
The court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
all right. So,
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple of days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these.
Yeah, they actually are. They are no material witnesses in Woody's confession. Huh, how about that? That would disqualify more or less the entirety of this prosecution and Judge Glanville. But we already know that will not happen because they are moving on with the trial as if nothing happened.
These proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, But I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank
And
you.
I've noted your motion for mistrial. It's denied. Okay, I'll,
Nobody
same thing.
surprised.
You want the Harvey? Okay, all right. Okay,
We're
Mr.
not adopting all of the same.
All right,
Good afternoon, Your Honor. Charge in that, on we have Mr. Marquez Huey.
okay,
We are also adopting all the arguments that have been made.
all right, sir.
Still by Attorney Adams, by Attorney Matt Sharp, by Attorney Douglas Weinstein. We also we were here at the appropriate time. And when the court did come out, we were not made aware that there had even been an communication that was had, that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court we believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. D. Williams? All right, thank you, Matt.
Now we know that Woody takes the stand later. He already has in real time. In cross-examination, do you think any of the lawyers will ask him if he killed Nut? I would assume somebody will. They might be banned from asking, but I don't see why they shouldn't, because they learned there is a confession.
Motion's denied. Mr. Garner? Okay, so noted. All right. Okay, Mr. Steele, last time. Who told you? All right, Mr. Steele's in custody.
Spineless
And
coward,
once he
Judge Glanville.
clears the area, we'll go ahead and get started.
If I let the court use it, if they start to resume the trial, Your Honor.
Yeah, we're gonna continue. I'm not calling nothing.
I'm not going to participate in the trial without a steal.
You don't have that luxury at this point in time, sir. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't. Sir, you all are really getting yourselves cross purposes at this point in time.
Are you to say that, Judge Glanville? Miss Love provably lied to you on numerous times, to the court, on the record, and you did nothing. There is a whole team behind her that could take over, but you don't, because somehow soulless Miss Love, Satan's whore, has you by the micro balls.
Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again?
Respectfully, I will not. I cannot.
Sir, you have to. Well, you're going to have to do the best you can at this point in time, because you don't get to extort the court.
You don't get to extort the court, but you are now denying Mr. Williams a proper defense, because Mr. Steele's co-attorney, he's not read up on everything, and now you're forcing him to do the work. That's another coercion.
That's what you're attempting to do at this point in time. Sir, yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly. Sir, I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you, at this point in time, there is nothing that was
You have all the information needed, but you have no spine because you're a part of the prosecution's team. You are now trying to save the prosecution's team by jailing the defense attorney for revealing to you that he got knowledge of your corruption.
whatever this morning. That,
If there is any accuracy to some of the information that we.
but sir, I don't even know your co-counsel. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No, it's not, sir. Sir, that's not what happened. That's not what happened. That's not what happened. That's not what happened. I'm just telling you this. That's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been. And the only
Okay, well then you made your. No, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me 1 moment to confer with counsel regarding the appropriate remedy in this type of.
Okay, all right.
Here, Ms. Love is expressing what she believes is, well, she tries to imitate having a soul by suggesting to the court that Mr. Steele be seated during the course of the trial, but will be remained in custody when it's not trial. Judge Glanville jailed Attorney Steele because Attorney Steele revealed to the court that he got knowledge about an ex parte meeting between Judge Glanville, the prosecution's team, an investigator, Woody, who is on the stand, sworn in, that the judge never told them about. They missed the entire morning in a meeting the judge planned to keep secret from the defense, where Woody confessed to the murder of Donovan Thomas. And Judge Glanville planned to keep this a secret until the trial was over. And now Mr. Steele is held in contempt. He's being jailed. But through the good grace of Prosecutor Love, he is allowed to sit in on the hearing, on the trial, but then he will be held in contempt. Yeah, contempt. Because he refused to reveal the source of his information. Because the judge wasn't interested in what the information was. He wanted to find out who told Attorney Steele. Who told Attorney Steele about the meeting where the judge and the prosecution coerced Woody into keep testifying. They coerced into holding this meeting a secret until the trial was over. So now he is jailed because Mr. Steele found out about the corruption. I agree. They're not supposed to be ex parte the court. And Woody was a sworn-in witness. And on the prosecution's suggestion to the court, we want to hold an ex parte meeting and don't tell the defense. And the judge agreed. Apparently, Woody again said, I will plead the fifth. And then they coerced together in getting him to testify, to continue testifying without pleading the fifth. No defendants, no lawyer from the defense side were even aware of this meeting. They came to court 8:30, 8:40, and then nothing happened until 11 a.m. when the judge started as if nothing happened. And then is when Mr. Steele, Woody got half an hour, and then they took lunch, and then somebody told Steele what happened in that ex parte meeting. No lawyer for the witness either, from the look of it. Well, he had representation in there, but apparently Woody's actual lawyer, who was out of state today, claimed that, oh, no, this woman is not his lawyer. So there's so much shadiness going on. How long will Steele be in contempt? Well, until he reveals his source, according to the judge, which will be to the end of the trial.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I denied your motion, but I'll certainly take that under advisement, sir.
Is this criminal contempt?
We're going to be
I
in
would
recess for the
assume
next
it
5
is.
minutes.
And then they go to a break. Let's skip ahead. Huh? Yeah, he was a sworn-in witness in the middle of his testimony when the prosecution decided they were going to conduct an
Is
ex
Mr.
parte
Adams in the
meeting with
hallway
the
over there?
judge,
Could you get him, please?
which is until the judge says otherwise or the end of this trial. That is my understanding, is how long Mr. Steele will be held in contempt. The rule book says 20 days with an extension. But I believe in the Georgia rules about criminal contempt is when the judge says it's in the course of a trial, it is 80 days and or the end of the trial. Now, normally that is because a trial often is shorter than 80 days. But in this case, a year and a half.
Wait.
Is this possibly an interlocutory appeal situation? Yeah, if the judge allows the appeal to be sent. Or I assume the Attorney General can move in, but I don't think they will. How many ethics violations did the judge commit? All of them. Because as I previously stated, he is as much part of the prosecution's team as any of the soulless monsters who are currently there. Miss Love, Miss Hilton, and the other three who I don't care enough about to learn their names.
Your Honor, Mr. Adams is present.
Yeah, and Judge Glanville is the chief judge. There's nobody in Fulton County that can tell him what to do. He runs the show in Fulton County. He's the chief judge. The only people who can throw down the hammer on him is a higher court.
Let me address your first refusal to go forward. We have had plenty of circumstances in this trial where you have been lead counsel and you have done more than a yeoman's job of representing Mr. Williams, and I don't doubt that won't continue. So you don't get to have your entire defense team here. You certainly get competent counsel, which the court finds that you are in this particular circumstance. And an appellate court will review my decision for abuse of discretion. So I'm going to direct that you go, that you continue to represent Mr. Williams. You can consult with Mr. Steele. Any breaks or anything like
Yeah, that is what the judge is counting on, that whatever he does in this trial, he is searching for a conviction, and he really don't care what the appellate court does later. I don't think he cares if it is overturned, as long as he gets the convictions. And then he can always blame the higher court for being stupid or wrong or politics or anything or racist. I don't fucking care. This is the court. The justice system survives bad people getting acquittals. It has a hard time surviving when the bad guy is the judge.
such as that? I'll allow you to do that and continue to do that. But Mr. Steele put himself in this particular position in terms of all these. I'm not asking him for any.
No, Mr. Steele didn't put himself in this situation. You put him there. Miss Love put him there because you allowed a sworn witness, the prosecutor and yourself, having an ex parte meeting in the middle of his testimony. And you decided to not even tell the defense about it. And Mr. Steele found out. And now you're punishing Mr. Steele for your corruption.
Or you for any other information that might be privileged or any other conversations, but I need to know who told you, because that then drives other things the court needs to probably do. So he's the reason as to why we're here in this particular circumstance. So if you or he or want to disclose to me who told you that, I'll be more than happy to reconsider.
I know Mr. Steele will not. I also will not. And I respect his court. I respect the court has to do whatever it is appropriate. But I would ask the court also respect my representation of Mr. Williams and standing for him when we believe that there's been a violation that affects his right to a free trial. And we believe that that's the position we're in. And I would respectfully decline the court's order of continue forward.
Your Honor, may I?
Sure.
Address the court. Thank you. Your Honor, there are two things at issue here. And one of them, Your Honor, is that
The court, how it is that the state has any position in this particular conversation.
As Dave says here, judges are required to recuse themselves for my appearance of bias. This judge doesn't care. He's the chief judge. He just got re-elected. He can stand up and piss on the Constitution, and nobody could do anything about it until the Georgia Supreme Court says you're out of line. Hey, Bakerade! I assume that the Karen Reed trial is over for today. For you who just joined, hello. For you who just joined, you need to go back about 45-50 minutes because I can't, with words, give an honest, compressed of what just happened. You need to see this absolute foster clock of all foster clocks by yourselves. Go back 45-50 minutes. Watch in 1.25, 1.5 speed, and you will catch up. Yeah, judge just throw a defense attorney in jail for calling the judge out on an ex parte meeting he had with the state and a sworn-in witness in the middle of his testimony. In that ex parte meeting, this witness confessed to the murder of Donovan Thomas. The state's case is that Shannon Stillwell committed this. And the judge and the prosecutor decided to withhold this information from the defense. They decided to withhold the information. There even was an ex parte meeting from the defense. The defense found out, and the judge decided to punish the defense for it. Go back 45-50 minutes. You need to see this. I can't do it justice. You need to hear it yourselves.
Before we recessed, Ms. Love said that she was going to research this ethical issue because it is an ethical one. So just much like you could add to it, I'm asking the state if they...
Asking Satan's horde to research ethical questions is like asking the mouse to guard the cheese.
wish to add to that as well, sir. Okay?
Yeah. Thank you, Your Honor. Your Honor, we believe that there are two matters at issue here. One, obviously, is Mr. Williams' right to...
Do you know who should be researching this? He should have called the state bar. He should have recessed for the day, called the state bar to come down with their actual opinion. Yeah, this is Georgia, Fulton County, Georgia, Atlanta area.
Counsel of his choice during the trial of the case. We believe that the court has the discretion to fashion any remedy, any punitive remedy for contempt that it chooses. We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial. We believe that it will need that so far this issue alone has needlessly delayed the trial of the case, and we believe that it may be in someone's best interest and in others not in their best interest for that delay to continue. So we would ask that the court, notwithstanding the finding of contempt, allow both Mr. Williams, Mr. Steele, and Mr. Adams to be present while these proceedings are going on and while court is in session. Physically.
I think that would be appropriate under the circumstances. And Mr. Steele, certainly I can inquire about before the end of the day if he wishes to disclose that information that I've asked him, then he certainly purges himself of that contempt. So yes, that's fine. We'll go ahead and do that.
And the second thing that I wanted to put on the record is that there was no substantive communication with any witness in this case outside the presence of any counsel for the defendant.
She claims there was no substance between it that was heard in that. He confessed to the murder. He said in that meeting that he did it. And now Satan's whore, also known as Prosecutor Love, is claiming, oh, no, nothing of substance. This is so vile.
Or any defendants in this courtroom. The matter, Your Honor, if I may finish, the matter that the state requested an ex parte audience with the court regarding was a matter to which no one to my right was a party. It was a civil contempt matter, and
Doesn't matter if it's civil contempt matter. You held a meeting with a sworn-in witness in this trial, and you try to keep that as an absolute secret from the defense, where you coerced this witness into continue to testify without pleading the fifth. You and the judge coerced together as a team. And somehow that is on the defense. Calling it a civil contempt and they shouldn't have known about it. Bull crap. Bull crap. How any of these are allowed to practice law on the prosecution side and this spineless judge is beyond me.
the parties towards that civil contempt, the state, which moved the court to compel someone to do a thing, the court compelled, and the state said, Your Honor, we're asking if they don't comply, that the court hold that person in contempt. That was a civil contempt matter. Nothing substantive was discussed. Everything was recorded, and the representations made, at least by persons who were present, to the...
If Mr. Woody was planning on pleading the fifth again, that should have been a hearing in front with the defense there hearing it. That is not the situation to claim an ex parte.
state is that when questioned or queried about it, is that that person was told or asked whether things occurred, and that person relayed that no substantive communication took place during that meeting. So that is the second matter. And first and foremost,
which we know is a lie, because Mr. Steele more or less read and quoted what happened in there, tried to get that on the record, and the judge ran out saying we are in recess, just to avoid it being said on the record. In that meeting, Mr. Woody confessed. I don't know. Can he be disbarred? Sure. But he is elected. There are elected judges out there without even a law degree.
we just asked that the court again allow both counsels for Mr. Williams to be present when court is in session, so that we don't delay these proceedings further.
All right, that's fair enough.
Thank you.
Okay.
And it is so vile that she's saying we don't want the defense to hold up these proceedings anymore. This trial was scheduled for 6 months. We are now over 6 months in, and the prosecution isn't even halfway through their case in chief. This is witness number 80 or something out of 209. And she claims it's the defense who is holding up the proceedings. No, the defense is only doing their job, their obligation to zealously advocate for their client. The person holding up this is Miss Love and her boss, corrupt Fannie Willis, the worst whore in history who has to pay men to sleep with her.
Sharp.
The ability for the state to paint themselves as the victim constantly in these matters is unbelievable. We are the aggrieved party.
Sir, we can't hear you.
My client, Shannon Stillwell, and these other young men sitting here as defendants are the aggrieved parties. We were not present. I would like to reiterate.
But here's the problem. Here's the
Your Honor, can I
challenge,
just-
Mr. Sharp. Here's the challenge. You got the information in a way that was not lawful to begin with, sir. That doesn't alleviate.
Judge Glanville is going sob-sit. It's not lawful. It's not lawful. It's not lawful. And he won't let the defense speak. He's doing everything in his power to avoid them having their argument read into the record.
The information or make it less valid or invalid. So because we record these conversations so that they can be reviewed later. We didn't have any conversations that were not recorded. And if you heard of other conversations that were made, I don't know how you would have gotten them otherwise, because somebody had to tell you.
Okay, well, all that's.
And like I said, if and when the case gets reviewed, an appellate court will make those decisions. But
if they get convicted, just getting the records out of this will probably cost them in excess of $1 million. Just claiming, oh, they can review it in an appellate court. They have to first get all the records out. They have to pay to get all the records out. Then they have to prepare and everything. This is a multi-million-dollar cost for the defense because whatever's, let the appellate court. And that is his strategy. He's done it before. And Mr. Steele has won appeals against this judge several times. But the state has infinite resources. And the defense hasn't. And the judge knows it.
at this point,
My client is the aggrieved party. He was not present. If that violated his Sixth Amendment right to be present.
okay, and that's your argument. Sir, that's your argument. That's your argument.
One other thing, Your Honor.
That's your argument.
All I'm asking for is some sunlight to come over these proceedings.
Sir, this is not an open meeting. This is not sun. This is not a sunlight situation.
Release the transcript and then we can see, because we do not accept Ms. Love's representation.
Okay, you don't accept the court's representation? I'm telling you.
Like the transcript.
I'm telling you at this point in time, when the case is reviewed on appeal, if
This is so vile. Reviewed on appeal. Judge knows that is a cost that maybe only Mr. Williams can take upon him. And it's still, it's so wild. Yeah, Dave went back and the judge immediately jumps on, who told you, but does not deny it. Yeah. Everything Mr. Steele said is information he got from that very meeting, where Woody confessed to the murder. This is a central part of the prosecution's case, that the killer of Donovan Thomas is Mr. Stillwell. That is exculpatory evidence. And I don't care if the judge says it was a civil matter, a civil contempt matter. If they learn, if the prosecution learns of exculpatory evidence, even if they don't believe Woody, they have to reveal this to the defense. But they are hiding between, civil contempt, blah, 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 blah. It's still exculpatory evidence. I do not believe, even if it's a civil matter, that they have the right to conceal this from the defense.
if I am wrong, then certainly the appellate court can tell me, and certainly there are other bodies in Georgia that certainly my conduct can be reviewed by. But at this point, I'm telling you that's the sum and substance of it.
We are trying this case right now to win this case. We are not playing for an appeal. We would like a fair shot at this case right now. We would like the transcripts. We all know that the appellate process in this case is probably going to take decades.
Okay, well,
So
at this point, I'm, like I said, I need to have a little bit more information in order for me to kind of make some other decisions.
And now Judge knows he can't run away again, screaming, recess, recess, and then run out the door. So now he's running away in and out. Now he's hiding between, oh, it's civil. Oh, I need to find out this. No, you are perfectly in your right to say you are correct, defense. Here is the transcript. But no, he hides it for the appellate courts to review, because he knows for all the defendants but one, that appeal is too costly.
In this case, not saying that you may or may not get that information, but at this point, there was nothing that was improper about in the ex parte conversations. The court's more concerned about is the disclosure. So, and
I understand the court's concerned, but as the counsel for Mr. Stillwell, my concern is the meeting that he was not allowed to be present for.
okay, all right. Thank you, sir. Are you going to repeat the same thing again? Oh, let's try not to, because the Harvey rule's in effect. I understand everyone's opinion at this point in time.
The only thing I want to say, and to not be repetitive, but on Friday, Your Honor, this particular witness came in, he pled the fifth, his lawyer was present, his lawyer stated to Your Honor that he had spoken to his witness, his client, and he stated that the witness indicated that on Monday, he will also be saying that he will plead the fifth. And then, Your Honor, there was a 2-3 hour span this morning, and then he comes on and he says, I'm going to testify. That's why I believe in the application Huey that the transcript is important.
Okay, thank you, sir. All right, let's get Mr. Steele out, please. You can tell him to put his tie back on. And then we'll go ahead and get started at that point in time, okay?
Yeah, I'm currently trying to get Steve Gosney here, if you have time. If you don't know who Steve Gosney is, you're missing out. Steve Gosney is a Florida-based lawyer who is death penalty appeal certified. If anybody, I know he's not from Georgia, but he does know about appeals and stuff. And here he is.
Hey, Nick.
Hey, good to have you here.
Hold on a second. Let me mute this here. Mute that. Okay. Sorry, I kind of wasn't planning on coming on anything today, but I saw Sean's channel, something about an attorney being held in criminal contempt in the young Thug RICO-Trial. So I went over there and I watched the exchange and the judge and this little moment. So I haven't been following the trial, but I did see this. So you called?
Yeah, I mean, I have never I'm not US based, so I can only speak from my experience covering US trials for this year and a half or so. But in my opinion, even now, the judge claims and the prosecution claims that the information that was revealed in this ex parte meeting with a sworn-in witness was regarding civil contempt, which means they claim they are not supposed to reveal this. And for me, that is astounding, because if in that meeting it is revealed that there is a confession which absolutely has to do with the case, the prosecution is obligated to reveal this exculpatory. Even if the judge and the prosecutor believes it's bullcrap, they still have to reveal it.
Yeah, there's a lot of problems with what's going on right here. And I just tuned in. I haven't been following this case, but from my understanding, you have a witness on the stand who has pled the fifth and has taken a criminal contempt or a contempt proceeding. He's sitting in jail because he refuses to answer questions in the face of a prosecutorial immunity offer, right? So he is basically saying, you have to, I'm ordering you to testify. And he's saying, I'm refusing. So the judge is holding him. So the witness is on the stand. Now, I will say, if the witness asks, if he was on the stand, he was asked, I want to talk to my lawyer before I answer that question. The judge would say, you cannot do that. Okay. The witness is not allowed to talk with anybody while he is on the stand about his testimony, right? So what is done here is, so evidently the judge and the prosecutor don't like the fact that he's there. They want to explain something to him. So they get him and they hotbox him. They talk to him without the defense attorney present, which is unreal. First of all, they're not supposed to talk to the witness while he's on the stand in the first place. Second, to exclude the defense attorney is a problem. And third, now there's a record. The judge has just made himself a witness. Now there's allegations of like, well, why is he changing his mind? What did you say to him to change his mind? That's the subject of cross-examined material that needs to be disclosed to the defense. The judge is saying, I have a record and I'm not going to tell you about what's in it. So now I don't have the ability to cross it as a defense attorney. You got a witness. I have the right to confront the witness. What was the deal that made you spill your guts? Did they say, we're going to let you out? That's what the allegation is. And the judge is now a witness. I mean, the judge to me, there's a lot of problems. There needs to be an interlocutory appeal. The judge should be disqualified, should be a mistrial. And it's definitely an appellate issue, but I think it's an immediate issue right now where the appellate court should step in. They should do an emergency interlocutory appeal to the appellate court to disqualify. Now, there hasn't been, I don't think there's been a judicial disqualification motion, but the defense attorney should move to disqualify the judge right now.
Yeah, I mean, they have done it orally on 2 occasions, and the judge told them you need to put it in writing. Then they chose not to, because in my opinion, they are avoiding it because then everything starts over.
Right, I get it, but there's at some point you have to do it. And when I was younger, I used to be a lot more reticent to disqualify a judge. But now I'm much quicker on the trigger. As soon as the judge is acting like this and they are just not operating according to law at all, and he's concealing stuff and threatening you, man, you need to get that judge out of there. I would be immediately filing a disqualification motion on this judge. Yeah.
And this by claiming they can hide behind it, because his contempt they claim now is a civil contempt, because
that's the distinction. That has nothing to do with anything. The judge was threatening. I did watch some of it. The judge was saying there's attorney-client privilege issues. That is not the position of the judge. First of all, attorney-client privilege is when the attorney and the client are talking one-on-one. If there is a third party present, that breaks attorney-client privilege. And in this case, there's a judge present and a prosecutor at least. So there is no attorney-client privilege around that conversation. That is a complete red herring that this judge is throwing out there. He's accusing the defense of being unethical when in fact, he is the one that is behaving improperly.
Yeah. And now or Attorney Steele is held in criminal contempt for not revealing the source of this information.
Motions lined up. You know, you do an emergency writ of habeas corpus to get you post the bond, you do an emergency writ of habeas corpus. They will have that filed at the appellate court by the time he hits the jail. So I doubt he'll spend the night in jail.
Yeah, I mean, the Georgia Defense Association, I assume, is all over this, because if there is one.
Well, the association isn't usually the one that does this, but there will be attorneys in the back, that are assisting, that are going to be drafting it as we speak. So as that witness is testifying, there's an associate or somebody typing up the interlocutory. It's an emergency writ of habeas corpus that goes to the fifth. That's my appellate court. Whatever appellate court is. And this is exciting stuff. This is good.
And the judge claiming, the appellate court can review this on appeal. I mean, we are almost 7 months in, and we are not even halfway through the prosecution's case in chief. Imagine the cost of just getting the records out.
What is the problem with this case? Why is it taking so long?
The prosecution, it's a RICO case. The RICO charge has 196 underlying and overt acts. Then they have additional charges besides that. One of those is this, what they are going through now, the drive-by shooting and subsequent murder of Donovan Thomas, which the state's case is that Shannon Stillwell, one of the defendants here, is the perpetrator. In this meeting, apparently, the witness sworn in said he did it. So if that isn't exculpatory evidence, I don't know what is. And it's not revealed. And the judge wanted to keep this meeting a secret until the trial was over, and only reveal it in the records after.
You see, and there's so many problems with what's going on. Okay, so I do criminal appeals in Florida. This judge is saying there is something in the record that he has considered. It's in the record, so there's a transcript, right? And it will be revealable that the defense attorney right now in the trial can't look at.
Yeah.
And it's communication with a witness that's on the stand.
Yep.
Who changed his mind about his testimony based on conversations with the state attorney's office? What did they promise? This is Brady material. This is major, major stuff. This is mistrial. This is a disqualification of the judge, and to hell with the cost at this point. The state's the one that's not trimmed their case. They need to be much more efficient. Obviously, I haven't watched it, but if you're doing an 88-jury trial, I don't care. They're doing something wrong.
No. Now, the state in the beginning of the trial had 740 witnesses.
Yeah, that's ridiculous.
The judge ordered them to trim it down twice, down to 400, and now 209. Now, last week, they had two rental car, the rental store clerk, and his manager testify about how Mr. Young Thug or Mr. Williams rented two cars. And they testified about that for a combined 5 hours.
Yeah, it's, there's stuff.
And that's the trimmed down version.
Yeah, I mean, but there's a trim down. There's witness trims, but then there's also how you question them. So you got a witness that says, okay, this guy rented the car. You put him on, says, okay, so you had this rental car company. Did you rent an SUV, Chevy SUV to Joe Blow here? Yes. Is this the document that you did? Into evidence? No further questions.
Yeah.
5-10 minutes.
They had both talk about the how do you rent a car?
Yeah, he
Can
says,
you just walk in? Can you pre-rent?
No cure. I'm sorry.
No cure san.
Yeah, it says Brady was raised and judge denied it. But see, the judge has nothing to do with denying Brady. Okay. The fact is that the state has an obligation to provide Brady material immediately when they come into possession of it to the defense. And so the failure to provide that, and this is critical. Now, maybe there's nothing, but then why not provide the transcript, right?
Yeah, if it's nothing, why not provide the transcript?
And then I guarantee you that when that kid comes back and the defense starts crossing him, the first thing out of their mouth is going to be, who did you meet with? When did you meet with? And the judge is going to not like it. He's going to shut him down. He's going to keep him from exploring that. But that goes to the motivations about why did he change his mind about testifying?
Yeah. And one of the questions, because Mr. Steele is already held in contempt. He's already up on the stand, and they are continuing as if nothing happened. On cross-examination, if I were Mr. Steele, now I don't risk anything because I'm over here. My first question would be, did you kill Donovan Thomas? And before the prosecution can object, he will say yes, because he has immunity. The prosecution offered him this immunity card, which completely erases the Fifth Amendment.
Well, so it's a mess. I mean, this is. I'm just popping in. Do you have any other specific questions? Because I actually have some paperwork I'm working on multiple things. But I know you invited me, and you were called. I heard the Nick call from Sweden.
No, I just wanted your input just to reaffirm me that I'm not totally out of there when I
This
make
judge-
these claims that it doesn't matter if it's civil, you have to disclose. If this information is in there and it is exculpatory, you have an absolute obligation to turn that over to the defense. And the judge actually sealing this meeting because it's a civil matter doesn't matter.
That has nothing
Now-
to do with anything.
Now, you wouldn't like the words I've been using lately. I don't know if you heard. According to me, prosecutor Love has no soul. She can't have. I mean, and I may or may not have called her Satan's whore.
Well, that's pretty harsh.
Yeah.
But I don't
Yeah.
know about that. But I'm just yes, I'm just here doing my job. Look, I've got. I'm sorry, I got some others. I got so much going on right now. But hey, I think Thursday night. Can I plug something while I'm on your wonderful channel?
Sure. Plug anything you want.
Well, I'm not sure how much stuff I'm going to be able to do, but I know on June 21st, I will be unemployed and not employed by anybody. So I've released a new book called Death Penalty Designs, Maximum Due Process, this is a draft. See, it's a not for resale. So I think I'm going to have a Thursday night release party. And this is an analysis, a legal analysis of Florida's death penalty system. So it starts with the history of the death penalty in the United States, a federal case law overview, and then all of the reasons that Florida's death penalty statute is out of sync with federal case law and the Constitution. So that's what this is, and it is my masterwork on the death penalty. As I say, bon voyage to the death penalty. This is my final gift to the legal world. This is a very hard law in the same sense as Ideas and Answers in Law. And so that'll be released June 21st. I'll probably have a party on Thursday, this Thursday, to release it. I don't know, probably a drinking stream. So I want to let you know.
Yeah, I mean, that is just around where we have our midsummer. So I would probably be able to join if you invite me.
All right, cool, man. And I'll be around, but I just have to do a couple things. I'm sorry. I didn't want to stream today, but this broke, and I thought it was interesting.
Yeah, I mean, I've not here in Sweden. This I cannot see this ever happening.
I've never seen an ex parte meeting with the judge and a witness on the stand. I've never heard of such a thing. And that to me, he could lose his judicial seat over that, because to me, he is really stepping in it. I don't know. Yeah, maybe, but I'm not a Georgia lawyer. I don't know. Georgia may have different rules, but I've never seen anything like that. That is ridiculous to me. But maybe Georgia's got a different set of rule book. I don't know.
Yeah, and here's the thing. He's the chief judge. He doesn't have a chief judge that can tell him, "Oh, you screw up." Yeah, it has to come from the appellate court or the Georgia Supreme Court.
Yes.
And he is adamant in running this trial to the end and get a conviction.
Yeah, well, that's not the purpose of the judge. If people need to play their roles properly. This very, I don't know where we lost it, but so few. This defense team is right on the money, okay, but the judge is out of line, and I don't know what I don't know what's going on here, but people gotta, you play the role. It's a system. It's a criminal justice system, and the parts need to play properly in order for the system to work. When you have when a judge is trying to be an advocate and putting his thumb on the thing, that's not being a judge. You call balls and strikes. You're the referee. You're not an advocate.
Yeah. And the amount of times when they have either a hearing or anything, and the judge is not only allowing the prosecution to, he tells them that is not sufficient, you have to try another way. And then when the defense gets up to argue their point, he always interrupts them, and then he brings the arguments that the prosecution should give. He should be the gatekeeper.
Yeah,
they should move to the prosecution. Now I'm listening to the defense. Here is my ruling. No, he listens to the prosecution, gives them advice to how they will get this part of evidence in, if he believes.
What you might see is a motion, a written motion to disqualify the judge tomorrow morning. If I was to guess, because they're not going to do it off the fly. They're going to go back and they're going to confer and think about it, but then they're going to do a written motion to disqualify the judge with sworn accusations and allegations. And so that's that. I'll just put a little prediction out there for you.
Yeah, I really hope they will this time, because now, even if I understand the notion that this will be a 1.5 year long trial. They already been in jail for 2.5 years at this time. They want the defense probably wants this trial over with so they can get direct to the appellate, to the appeal. But they also want to win this case.
No, they want to win the case. You want to win it. You want to win the case.
Yeah, but it's hard to win the case when the judge is sitting at the prosecution's table.
Okay.
Yeah.
All right.
Okay.
I got to go. I'm sorry. I'm
no worries.
Thanks,
Thank you so
for letting me
much.
on. See you around, man.
See you around. Thank you for being here. Yeah, folks, that was a death penalty appellate certified attorney. Yeah, Steve Gosney. So I'm not out of line. I think Mr. Gosney even went further than I did. I use harsher words, but I do believe Mr. Gosney went further than I have done so far in this stream. But let's continue. We are a bit behind.
To the court's suggestion that you be here until when we in all open sessions of court and until we finish for the day. So I'm still going to hold you in contempt. You can purge that contempt by just telling me who it is that told you this information. That's all I need to know. But at the end of today, I'll ask you that question again today. We did not take up any business in your absence, other than Mr. Adams eloquently saying he was not going to go forward without having you present with him. So, and him not wanting to divulge who the information came from either. So, with that, sir, we're going to go ahead and continue. All right.
Ask a question.
Yes, sir.
Did the court order the transcript that we can see it and have a hearing with all witnesses?
No, I'm not gonna order the transcript as of yet, because if the case should be reviewed, the appellate court will have that particular ability to do that. I don't believe at this point in time, it is the court's understanding of the ex parte conversation that the disclosure is the more troublesome remedy. If I did something wrong, then certainly that can be reviewed. But I'm not at this point in time going to release any of the.
You helped the prosecution to hide the fact that there is exculpatory evidence, and you believe you did nothing wrong.
Transcript in terms of what may be disclosed or that was said in Chambers ex parte at this point.
Well, I was told based upon information belief that it would affect this witness's testimony in front of the jury, because I was told based on information belief that depending upon how the day goes, he may go home or not, depending upon his testimony. I'd like to know what that's about.
I don't know, Mr. Steele.
Oh, holy crap. So their suggestion to this witness who confessed to murder was keep testifying and you can go home. A person who just confessed to murder, they offered you can go home as long as you keep testifying against these defendants. Jesus Christ.
Oh, I don't know. I mean,
you
that's
know.
why I would like to know who it is that told you or disclosed this information from Chambers, because I don't know if this person even had, if that conversation was even had within my presence or hearing. I don't.
So I would like to have a hearing with the court as a witness, with DAs as a witness, with the deputies as a witness, with Mr. Copeland as a witness, with his counsel as a witness, court reporter, transcript. And Judge, I'm not trying to be harmful.
Mr. Steele, I think that you're running a very thin professional responsibility. I don't think you have cover at this point in time. I think you're blowing your coverage at this point, because
Judge, you're a disgrace. You should have left law when you left Afghanistan to the Taliban. Now, this is Judge Glanville's judicial system, which he implemented in Afghanistan, is now helping the Taliban to find, prosecute, and enslave women and children in Afghanistan. I'm not using that word lightly. One of the penalties in Afghanistan is forced labor. There's another word for that: slavery. And this judge helped it happen.
I do think that somebody told you some things that violate privilege.
What privilege?
Attorney-client privilege. So, I mean, but that's beside the point at this point.
As Mr. Gosney just said, if there is more people in that room with the client and the attorney, there is no client-attorney privilege.
We're not going to argue about that right now. I just need the way you purge your contempt is that you just tell me who told you this. I'm not asking you what was said. But you're indicating what was said. I want to know who told it to you.
And I'm making
Okay.
information.
But I need to know who it is, because that's critical for the court taking remedial steps at this.
That is critical for the court in order to punish the person who revealed your corruption.
This point in time.
You holding me in contempt.
No. Yeah, I'm holding you in contempt because you won't tell me who.
How could something, I'm not trying to be obstruction, but how could something be attorney-client privilege happen before the court?
Well, because if somebody's a represented party and they disclose the information that to you all as parties in this case, that could be a problem. That could be a problem.
I don't.
I mean, like I said, I don't know what was said to you. I don't. I'm
trying to get out.
Well, so that's improper at this point in time.
Why?
Because you are telling the court conversations that you are privy to in my chambers that I know you weren't present.
But the court was present. That's what I'm trying to say.
That doesn't make a difference, but you got information that you shouldn't have had. And
You got information we tried to hide from you that it's exculpatory. That is what the judge is saying here. By the way, Steve Gosney was right. Here it is. In the Superior Court of Fulton County, State of Georgia, notice of appeal. Notice is hereby given that Brian Steele hereby appeals to the Court of Appeals of Georgia from the order of contempt of June 10, 2024, holding Brian Steele in criminal contempt. The clerk will kindly take note that the transcript of evidence of the proceedings on June 10th are included with the record on appeal. No other portion of the record is to be included for this appeal. The Court of Appeals of Georgia has jurisdictions over this case on appeal. Signed, Colette Resnick Steele, which is his wife. So it wasn't even, Steve, you were wrong. It didn't happen tomorrow morning. It happened now. Let's get back to the first o'clock.
then you turn around and say, well, the court did something wrong and that we should be entitled to have the transcript. You all have contorted and perverted that particular process. You really have.
You hid exculpatory evidence.
It's not, it would be just like if you all in the past have had ex parte conversations with the court. And I won't say about for what.
They have never had ex parte in your chambers with a sworn-in witness. It's not even in the same universe, you absolute fucktwat. Oh, sorry, YouTubes. I meant 4-quad, nothing else. Now, I don't believe this stream will ever be monetized. Not after my commentary. But, yeah. Jesus Christ. Now, if you wouldn't mind, and if you have the resources, hand me a super chat or to become a member. It's $3 a month. That way, the time I'm spending here at 11 p.m. my time, when my alarm bell goes off at 4:30 a.m. If you wouldn't mind. You don't have to, but I wouldn't mind.
You and Mr. Adams and others. That is your right. And that little period or that little conclave of discussion with the court protects you and protects the system. It's recorded and taken down. So if it needs to be reviewed later, it gets reviewed. But you have made something out of it where I'm kind of at a disadvantage at this point in time. So because I didn't invite you into that particular proceeding, and I don't think you had a right to be there.
Well, all I know is what I told you, and there's more.
Okay. Well,
There's a witness testifying who met with the court and the DAs. That doesn't concern us,
Your Honor,
meaning the defense.
I think that for an ex parte conversation, in terms of what was said, and I'm not gonna keep continuing to discuss this because the transcript is what the transcript is, and it will say what it reflects. It really will, and the court will stand by that. But the other conversations that you may be privy to or may have been disclosed to you, they're troubling.
Thank you so much, Ms. Snivels. Thank you. Gifted 10 memberships. That is an amazing gift to give Snivels. And it was given to Eric Rose, No Coercing, Lolita Smiles, Carl Puristic, Rachel Hope Brintesen Engelhardt, Monica Fron, Concrete Rose, Rabid Rose Werner, and Jim Schuler. Everybody who was gifted, you now have access to all my members-only content, which is a lot. It's about the farm, the renovations, my personal thoughts, and stuff like that. Thank you so much, Snivels. Thank you so much. You're a true champ.
They are. That's why I've got to find out who it is that disclosed that information. So you have the keys to your own contempt. I don't want to hold you in contempt, sir. I don't. I'm not asking you to tell me what was said between the two of you, but I do need to know who told you. So if you're willing to tell me that, that's fine. That will purge your contempt. If you don't want to, then, I'll unfortunately have to look at and waiting to get that information. So you can let me know.
Did the court put this in order?
In terms of what, sir?
I suppose.
Yeah.
It's criminal contempt. It's sua sponte criminal contempt, sir. You don't get to appeal from this.
Are you serious, Judge? Did you just try to deny Attorney Steele the right to appeal your decision to hold him in criminal contempt? Well, we know that doesn't work. That is just so stupid. Now the judge is just making things up in order to save himself.
You will go into custody at 5 o'clock today or whenever we finish if you don't tell me what that is. Tell me who that is. This is criminal contempt. I have asked you a question related to this particular proceedings, and if you don't tell me, then you'll suffer the consequences of that. Unfortunately, like I said, I'm not looking to hold you in contempt. I really am. I'm not. But this is that important.
Important. It is important.
Okay. All right. So you got to think about it. All right.
Can I just last thing going forward is over objection because I believe that we're entitled to these information, especially with this witness.
All right, sir. I'll note your objection. It'll be continuing objection for the time being. And I may make some other remedies depending upon what information I find later. Okay? All right.
On behalf of Mr. Steele, I'm going to review
Our Brady demand for any Brady material
Yes, sir.
that came out from any conversations with Mr. Copeland, between Mr. Copeland and the district
Yes, sir.
attorney's office this morning.
And here we have the Brady violation, which the judge aided the prosecution in hiding from the defense. Mr. Shard is Mr. Stilwell's attorney. The state charge is that Mr. Stilwell killed Donovan Thomas. Now they have the information that somebody has confessed, and they try to hide it from the defense.
Summon our jurors, please. Yeah, bring him out, please. fine. Someone agree, please. All right, Ms. Hilton, go ahead now.
Can you hear me? Can you hear me? Okay. When we left after court, I'm going to approach you with some items. Your Honor, may I approach the witness?
You may have shown those to counsels already.
Yes, this is what they saw right before we took lunch. Mr. Copeland, I'm going to show you what's been marked as State's Exhibit 350Y, 351Y, 342 Yankee, and 356 Yankee. Can you take a moment and look at those pictures? Please look at those pictures.
Do I have to look at?
Yes.
And now they try to continue as if nothing happened. With what?
I'm going to start first with
Old fucking photos. Social media photos, as if nothing happened. Another person. Did you know this person? Sure, I took pictures with him. So freaking what?
State's Exhibit 350 Yankee. Do you recognize who that person is?
I can hardly tell.
Okay. Is that Shannon Jackson? Your Honor, at this point in time, I'm turning to impeachment.
Oh, rule, sir.
I'm also going to object to showing the witness altered photographs.
Your Honor, it's based upon the court's previous rulings.
Not based on it's not.
Let me see it. Can I see it, please?
We've never discussed these photographs.
Chris, did we in? It's 350.
As well, if you want to see the original.
Has 350 been admitted already? Okay, all right. Oh, you just so you're just showing him at this point in time. It's not been admitted, Ms. Hilton?
It has not been admitted.
Okay, all right. You have any further objections, sir? What's your objection to it?
Not altered photographs.
No, that's not an objection. What's the basis for your objection, sir? Do you have an objection as to the photo itself? Huh?
It's not as evidence. It's improper to show that photograph.
I'm not sure what Mr. Shar is calling altered. The only thing that has changed is based upon previous objections.
You don't want to come up?
And we have a sidebar, and you know what that means. It is sidebar counter number 202. Oh. If you missed the sidebar 200 celebration, it's in my what you call it, in my shorts, as in video shorts, not in my shorts. Yeah, I agree with Snivas. I wouldn't trust the transcript either at this point. That is probably why they want it in now and not give corrupt judge and corrupt Ms. Love a chance to alter it. Nothing would surprise me anymore with this judge. Right? He has a personal shredding machine in his office just to get rid of evidence of his misconduct.
Excuse me.
I'm going to show what I'm now going to mark as 342 Yankee Oscar for original. Mr. Shard, do you want to come see these?
Hit the thumbs up, folks. There are almost 200 of you here and less than 100 thumbs up. Come on, folks. It's YouTube. You know what to do. It's free. It's right there. Just press it. If you've been here more than 5 minutes, I'm doing something right. So please do me that favor and press that thumbs up. And subscribe if you haven't. So you can hear me yell at the prosecution and the judge as long as his trial continues.
Are those the same pictures you just looked at? For the most part, you shake your head. You just got to say yes or no for the record for me.
Yeah.
Okay. Now, we were at 342 Yankee, right? No, we were at 350 Yankee. Besides yourself, just tell me everybody else you recognize in 350 Yankee.
You said show you what?
Besides yourself, tell me everyone else you recognize in 350 Yankees.
But you might name the people that's in the photo?
Yes, sir.
Me, Shannon, DB.
Do you know the fourth person?
I can't really tell your face.
Okay. Does that appear to be a fair, accurate depiction? So does that look like you, Shannon, and DB back in 2014? 2013, excuse me.
I'll sustain the objection. You can rephrase me.
Does that have a date on when this picture was posted to Instagram on there?
What you mean?
Does it have a date down here? Can you see that?
I can see that.
Okay. But does that look like the three of you, DB and Shannon? Does it look like y'all?
I just said yeah.
Okay. Your Honor, this time the state would like to tender 350 Yankee into evidence. 350 Yankee Oscar into evidence.
Any objection to state's 350 Yankee Oscar? Hearing none, it's admitted, maybe published as you see fit.
Thank you. Now looking at 351 Yankee Oscar, do you recognize anybody in 351 Yankee Oscar? Who do you?
Wait,
Do you recognize anybody in 351 Yankee Oscar?
what you mean?
Do you recognize anybody in that picture?
Yeah, the same three.
Okay, so you, Shannon, DB?
Yeah.
All right. And does that look like the three of you back whenever you all took those pictures?
In my first time seeing this picture.
Okay, but is that y'all in the picture? Yes. Your Honor, this time the state would like to tender 351 Yankee into evidence.
Any objection to state?
And the prosecution gets pictures in through this witness who has never seen that picture just because he recognizes the people in it. And now the prosecution gets to, once it's in evidence, everything around that picture is allowed for another witness to testify about.
351, is it Yankee or Yankee Oscar?
Thank you, Your Honor. Yankee Oscar.
On that, I was looking for yes, if you have objections.
We're going to not publish that version. We're going to get,
Okay.
we acknowledge what his objection is and we have corrected it before we published it. Before we,
You want to show it to him?
if he can come over to Ms. Knight. Just-
Yankee Oscar.
State's Exhibit 351 Yankee Oscar.
Any further objection to state's 351 Yankee Oscar?
No, Your Honor.
All right, it's admitted, maybe published as you see fit.
Next, Mr. Copeland, I want you to look
Yeah,
at State's Exhibit
I would
342
assume every
Yankee Oscar.
defense
Tell me if you
attorney
recognize anybody
in
in
the
Exhibit
area
342 Yankee
is
Oscar.
moving into that
Wait, this one?
courtroom.
Yes, sir.
It's a show of strength as well to pack themselves in there to listen to this.
It's blurry.
Okay, do you recognize anybody in that picture, although blurry?
I can tell it's me, but I can't really tell who the other people are.
When you say it's blurry, can you see anybody else on there, or you can't recognize no one?
No, I could see, but I can't really see their face like that.
Okay. Looking at 356 Yankee Oscar. Do you recognize 356 Yankee Oscar?
It looked like me.
Is there anyone else in there that you recognize?
Most definitely me. I can't really tell who they is with me though.
Is that Shannon Jackson? Or Shannon Stillwell?
Now they do got a mustache.
Okay, so is this your testimony that is not Shannon Jackson in this picture?
All I can say, I can recognize me, but I never seen their picture before, and I don't want to say this him if it ain't him.
Okay. You have permission to publish 350 Yankee Oscar and 351 Yankee Oscar.
Yes, go ahead.
And he just testified, I don't want to say if that's him unless it's not him. And it's still admitted. Yes, according to the Twitter's, Ashley Merchant has been seen in the courthouse.
Now, first looking at 350 Yankee, are you able to tell us which one described by clothing? Where are you?
What you mean?
Which one of these individuals did you?
Which one I'm with?
Which point to you in that picture?
With the hat on.
Okay, there's 3 people with hats on. Which person are you with the hat on?
With the writing on my shirt.
Okay, what does the writing say?
Yes, this is the guy with immunity.
DRC, third YRC.
What does DRC mean?
DRC.
What does it stand for something?
You asked me what it means. DRC.
Okay, does DRC stand for something?
Not to my knowledge.
Okay, it doesn't stand for the robbing crew.
I'm not a robber.
Hold on.
Okay, that's fine. I'm asking you what it is.
Hold on. I sustain objection as to form. You can rephrase.
What does
I got this shirt.
okay? That's your testimony today. That neither DRC or YRC mean anything.
That's how I got the shirt.
Okay, I understand that. I'm asking you, is this your testimony that DRC nor YRC mean anything?
I'll rule the objection.
Is that your testimony? That doesn't mean anything.
I said this how I got the shirt. So the shirt didn't have no meaning to it.
Okay. Who else do you recognize in that picture?
I just told you, me and DB.
Right. I saw it. The jury did not see.
Oh,
So I
my
need
bad,
you.
my bad.
Okay. So which one is DB?
He died.
And I'm sorry to hear that. Can you tell me who he is in the picture, though?
What you mean?
Just tell
No
us what
goes.
is he wearing in the picture?
The immunity this prosecutor can give does
I can't
not
really see what he got on.
include
Is he the one?
does not include federal crimes. I'm not entirely sure it is immunity to all state crimes unless the Attorney General, as Dave explained to you yesterday or Friday, that it might involve statewide if the Attorney General was in on the writing. But I haven't seen the document. If it's only Prosecutor Love offering immunity, that only counts for Fulton County. So it's basically worthless.
The green hat or the one in the purple or the one in the blue New York Yankees cap?
You said green?
Is he the one with the green,
Okay,
greenish
yes,
hat?
I just didn't know the color.
Okay. So he's the one with the, like behind you a little bit.
Standing behind me?
Yeah.
Yeah.
Okay. And then you said you recognize Shannon in this picture. Where's Shannon?
With the blue on.
With the blue hat on, the New York Yankees cap?
If that's what it is, I guess.
Okay. All right. Thank you. And are you able to see on there the date of that picture, or is that blurry for you?
No, I can't see.
Okay. Looking at that picture, can you tell me about how old you were in that picture?
You look like I was in elementary school.
All right. But is it fair to say that it wasn't within the last 3 to 5 years?
Huh?
Was it within the last 3 to 5 years?
I've been in jail.
Okay. So it's fair to say it was before that. I just need you to answer for the record.
I've been in jail for the last 3 to 5 years.
Okay. So it was before that. This is yes or no?
I don't even know which one to say yes or no to.
Okay.
If I say yes, I'm saying yes to it.
The picture was before 3 to 4 years ago.
The picture when I was younger.
Okay. Next, can we please publish State's Exhibit 351 Yankee Oscar?
skip ahead a bit.
is that you
think.
or to my right. But it's fair to say
Because prosecution showing
I can't say when.
pictures,
thank you so much.
this has been done throughout the trial, and it is absolutely worthless in my opinion.
Now, we spoke about your relationship with Shannon. As your friendship developed, did you all share personal information with each other?
What you consider personal information?
Did you talk to him about your secrets? Did you confide in him about life, things that had happened?
Now, my seat go to the grave with me.
Okay. Were you someone, did you consider him like a brother to you?
Still do.
You still do. Now, outside of you and Shannon, did you all have another friend that you spent a lot of time with?
Meaning,
Is there any other person that the two of you collectively spent time with?
it's my all three of us together.
Yes.
A lot of time together. I don't know about it.
Okay. Is there someone that you spent time together with Shannon?
I spent time with Shannon with a lot of people.
Let me ask you this. You just said that Shannon, you still consider him like a brother to you. Is your relationship the same today as it was, say, back in those pictures?
Say that again.
Is your relationship the same with Shannon today as it was back when we were looking at those pictures?
No,
How has your relationship changed?
it's better.
It's better now? Why do you say it's better?
What you mean?
You say it's better?
I barely knew him.
Is your relationship with Shannon the same today as it was back in 2014?
I can recall 2014. I've been in jail so much.
Do you know someone by the name of Demekion Garlington?
Street name,
Little D.
for sure.
How do you know Little D?
I didn't birth him.
I'm sorry, say that again.
I almost birthed him.
You almost birthed him?
Yeah.
Tell the jury what do you mean by that?
I mean, he my son.
Okay. And let me ask you this. Do you know another person who's referenced as Little D?
What you mean?
Do you know someone who's called Little D from Cleveland?
Oh, I heard of him.
You heard of him. Okay, we'll talk about him in a moment. Now, the Little D that you said is like your son, is that what you said? How did you all first meet?
What you mean?
How did y'all meet? You say you like your
I
son.
don't know how we meet.
You don't know how y'all met?
No, I don't recall how me and him first meet.
Okay. How long have you known him? And if you're 32 now, just
I knew him longer than Shannon.
did y'all grow up in the same neighborhood?
Mm-hmm. Probably, but we never home.
How old do you think you were when you started hanging with Lil D?
I don't know.
If we're in 2024 now, did you start hanging with him when you were elementary school, middle school, or high school?
I
age?
don't remember.
Don't remember.
I know when DB died, this when I took him in.
Do you remember what year DB died?
I don't remember when DB died.
Do you know what section of the city Demekion is from?
There have
No, I
been
do
more
not.
filings. I will go through them
Did you all ever
as
attend
soon
school
as there's a
together?
natural pause in this.
I can go to school with my
Hey,
son.
look at
Okay.
that.
Well, when you say it's your son, how old is Demekion? If you're 32, how old is he?
Hello, Ian. Good to see you. What a clusterfuck. What an absolute... You have done criminal law. I haven't. I do labor law. That's my thing. But I've been covering trials for a year and a half. I've been sitting in on trials here in Sweden. I have never in my life seen anything like this. Never. And I had Steve Gosney on earlier. And Jesus Christ. Good to see you too, Ian. How are you doing? I'm doing good. I'm doing good. And the judge needs to start polishing up his resume. Oh yeah. But he's the chief judge. He can, in his own mind, he can hold on to every information here until the trial is over and then refer it to the appeals court. And he knows just appealing this case is $1 million appeal. And the only one of the defendants that can afford this is Mr. Williams. That is what he doesn't care what the appeals court does, in my opinion. I can send Ian an invite if you have time. Dun, dun, dun. I just sent you a link if you have the time. If you have the time. You can polish up your language before.
I don't know.
I know you're going to talk a little bit about it on
I don't
your
know.
stream later
Is he
tonight.
close
So
to aging
everybody
for you?
needs to go
What
to
you
Is
mean?
he
Ian
close in age to
when
you?
he goes through a bit of this trial.
He probably about 10 years younger than me. I don't know.
So you say Lil D is about 22 right now.
I don't know.
You say he's like your son. How often would you spend time with Little D?
What you mean?
So we will be here for,
How often did
I
you
don't
see
know
Little
for
D?
how long more, but I
Back in, say, 20.
just got the motion to set aside a contempt. So I'm going to, as soon as there's an, let's, you finish eating and we'll talk. We have 12 minutes, I believe, left of this. No, it's still
14.
ongoing.
2015.
I should see him around.
Okay. How often?
I can't say.
You can't say. All right. Did you speak with him over the phone? Did you speak with him on the phone?
Speak who over the phone?
Little D.
When?
And any time.
Yeah.
Since you've known him. How often would you speak with him on the phone?
Whenever I felt like it.
Okay. So was that every day? Was that once a week?
Whenever I felt like it.
Okay. So was that every day? Was that once a week?
Whole time.
And I understand until you answer the question, I'm gonna have to ask you again. So was that every day? Was that weekly? Was that monthly? What was it?
I don't know.
I'll go back in a week. How often would you see him?
What you mean? When are you talking about?
Back in about 2013, 2014, 2013 to 2015.
Well, yeah, he stayed with me.
Okay. When did y'all live together?
He didn't really stay with me, but he stayed at my residence.
Okay. Were you staying at the residence at the same time?
Well, I was in jail, so
Okay. So while you were in jail, he was living where you lived. Prior to you going to jail, which you went to jail in 2015. Is that fair?
I went to jail 2012, 2013, 2014, 2015, stayed in at 2019.
Okay. When you went to jail before 2015, were you in and out of jail?
When I went 2012,
In 2012,
2012,
how long did you stay in jail?
I got out 2013.
Okay. Did you go back to jail in 2013?
I got at the end of the year. I went back 2014.
All right. And then between 2014, did you get out of jail in 2014? Is that a yes?
Yeah, I got out
And then did you go back to jail in 2015?
2014. I went to jail like a couple times 2014.
Okay. So you were in and out.
Right.
And then in 2015, did you go back into jail?
Yeah.
And is that where you spent the long duration?
I went to jail a couple times in 2015. But the last time I stayed until 2019.
Okay. And it was the last time that you went to jail in 2015, June of 2015.
That was the last time, yeah.
Okay. And so prior to June of 2015, you were in and out that year between January and June.
Right.
Okay. In the periods that you were not in jail, did you and Demikian, or excuse me, Little D ever live with each other when you were not in jail?
In 2015?
We'll start in 2015, yes.
Nah, he didn't stay with me in 2015.
In 2014.
Ooh, Jasmine Hall says, hey, reporting from news inside the court. 20 lawyers just came in to show support. And Ashley Merchant, she's not Trump's lawyer. She is a co-defendant of Trump. Is there to represent Steele. And Steele's wife just filed a motion. Yeah, I read his wife's motion half an hour ago, I think. And now there is another. Well, also filed by his wife. It is motion to set aside contempt motion. And I will read it as soon as there is a natural break in this.
In those times that you were not in jail, did Little D stay
Right.
with you? And then what about 2013? The time that you were not in jail, did you and Little D reside with each other?
What you mean?
Did y'all stay with each other and Did he stay at your home at any time in 2013 when you were not in jail?
2013 when I started to get to know him.
Now, you said that he's kind of like your son. Did you all share things with each other? I'm talking about conversations, personal conversations between you and him, and vice versa.
Not no secrets.
Okay. But did you feel comfortable speaking to him? You did not?
Nah.
Okay.
I didn't feel, I don't know what you mean. Like, I didn't not feel comfortable. I didn't feel like some stuff we just don't talk about.
That's fair. Did you consider little D like a brother? I know you call him your son, but did you consider him like a brother?
I consider him my son.
Okay. Do you recall ever telling any detectives previously that he's like a brother to you?
I probably did. Ain't no telling.
Okay. Y'all permission to approach?
Have you shown that to the defense counsels already?
Yes. Well, no,
Just make sure you show it to them.
I will. Permission.
Okay, that counts as a natural break. Let's go through the motion to set aside appeal. And this is Mr. Steele's wife, a very accomplished lawyer on her own, who makes a list. Hold on here while I do this so we can see it properly. In the Superior Court of Fulton County, State of Georgia, Motion to set aside contempt. Comes now, Brian Steele, move on to Haran, and hereby files this motion to set aside contempt as in the above referenced case. In support of this motion, movement shows as follows. Remember, Judge Glanville said he can't appeal. Well, apparently he can. Movement is counsel of record for Jeffrey Williams in indictment number this in Fulton County Superior Court. The jury trial commenced on January 4th, 2023 and is ongoing. When they reference January 4th, 2023, that is when the jury selection started, not when this actual trial started. And at January 4th, I believe that when the prosecution told the judge that they were ready for trial, they had 70 witnesses. And then it tenfolded up until the trial. Today, on June 10th, the court, along with the state prosecutors, engaged in an ex parte hearing with a sworn witness for whom an order of immunity was issued. The witness has previously asserted his Fifth Amendment privilege and was held in contempt. The court and the state admitted on televised court proceeding that this meeting took place. Attorney for defendant Jeffrey Williams, Brian Steele, commenced proceeding in open court on June 10th, 2024, by disclosing that the defense had knowledge of this information, demanded same, and proceeded to make motion for mistrial. The trial court immediately inquired of Mr. Steele how he came into possession of the information and expressed outrage that Mr. Steele knew of this information. Citing State of Georgia Bar Rule 1.6, confidentiality of information, Mr. Steele declined to provide that information. Rule 1.6 states in pertinent part as follows. A lawyer shall maintain in confidence all information gained in the professional relationship with a client, including information which the client has requested to be held inviolate or the disclosure of which would be embarrassing or would be likely detrimental to the client unless the client gives informed consent, except for disclosures that are impliedly authorized in order to carry out the representation or are required by these rules or other law by order of the court. Comment 5 to Rule 1.6 specifically says Ian, don't shave while stressed or grow a beard. minorly bleeding, attempted to shave and missed a bit. Did you use the big razor? Okay. Comment 5. Because when you read rules, you also need to read the comments to the rules in order to get a notion how to interpret that specific rule. This is what I believe the judge and the prosecution is ignoring. The principle of confidentiality is given effect in two related bodies of law: the attorney-client privilege, which includes the work product doctrine in the law of evidence, and the rule of confidentiality established in professional ethics. This is highlighted. The attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. The rule of client-lawyer confidentiality applies in situations other than those where evidence is sought from lawyer through compulsion of law. Rule 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. Whatever its source. A lawyer may not disclose such information except as authorized or required by the Georgia Rules of Professional Conduct or other law. This means that the judge needs to or has to refer to law or the Georgia Rules of Professional Conduct. He didn't. He never referred. He claimed that Mr. Steele was wrong, that he interpreted 1.6 wrong, but he didn't cite law or statute for that matter. See also scope. The requirement of maintaining confidentiality of information gained in a professional relationship applies to government lawyers who may disagree with the client's policy goals. Number 7, I believe. We were at 6. Yeah, number 7. The court repeatedly demanded that Mr. Steele reveal the source of the information, claiming that the way that Mr. Steele obtained that information was, quote, unlawful. Here is Judge Glanville borderlining going into sovereign citizen pigeon business, in my opinion. Mr. Steele relied on Rule 1.6 and declined to provide the source of information, which was never alleged to be deemed confidential by any court order placed under seal or subject to a protective order. When we listened to the judge's argument, he never said that information was confidential by any court order placed under seal or subject to protective matter. His argument was that this didn't concern them because it's a civil matter. He never said it was under seal. Under the civil matter, he tries to conceal it until the end of the trial, until after the trial is done. But he didn't expressively say that this is placed under seal. Because now I'm picking out of memory. But if things are placed under seal, they can put a motion to unseal. If it's a protective order, they can object to that protective order. Now they can't because the judge never said anything. The court held Mr. Steele in criminal contempt for refusal to provide information and ordered that he be taken into custody. The court temporarily permitted Mr. Steele to participate in trial for the day, but has indicated that at the close of business, it will again address the matter and demand that Mr. Steele reveal from where the information was obtained. Based upon the information and belief, Mr. Steele will decline to disclose this information. Hours after holding Mr. Steele in criminal contempt, the court stated that Mr. Steele can only purge himself of the contempt by telling the court from where he got the, quote, information that he shouldn't have had. which means now the judge, I think the judge made a mistake here, a crucial mistake, because up until that point, it was all about where did you get information from, not the information in itself. But the quote here, and I do remember he actually saying this, information he shouldn't have had. Here's the thing. Brady says you have to turn it over. If it's exculpatory, you have to turn it over. It does not matter if it was a civil contempt hearing or ex parte whatevers. If information disclosed in that hearing can be exculpatory or can be subject to a Brady hearing, it must be revealed, in my opinion. And Steve Gosney was here earlier. That's what he said. Don't trust me. Listen to Mr. Gosney. Thus, the court has imposed an illegal and inherently inconsistent punishment for this criminal contempt. Moreover, the court has involved himself in these proceedings, and thus the court must recuse and allow these proceedings to be handled by a separate court. There it is, in writing. The judge needs to recuse himself. There it is. The thing that Mr. Gosney asked for. There it is, in writing. The judge must recuse himself. And hi, Ian.
Hello. How are you?
Oh, after 6.5 months of this absolute cluster F of a trial,
I think you might have your escape hatch. I'm just gonna say.
yeah. I mean,
this looks like an escape hatch to me.
Yeah. I'm not entirely sure how the judge can get away from this, but you never know. He's done interesting things in the past. But
This
now
is
they
unreal.
now you have actually have it in writing. They are asking him to recuse himself. And
Well, I mean,
I don't know.
they just have to, right? Because the judge has literally jailed the defense lawyer.
Yeah, I mean, Mr. Steele has on numerous occasions said, "I am prepared to to have my bar card on the line for this." And
I
now,
mean, and the thing is, the judge basically said, "Well, I'm willing to have my, judicial discipline on the hook as well when he's taking these actions." And the defense lawyer just said, "Call."
yeah,
Like, cards on the table, call.
yeah. And the judge is so upset that he has made a few mistakes here. Now, had he continued to say it's not about the information, it was disclosed. But as the quote was here a bit higher, no, here, 0.9. The court, hours after holding Mr. Steele in criminal contempt, the court stated that Mr. Steele can only purge himself of the contempt by telling the court from where he got, quote, information that he shouldn't have had.
The contempt power is not intended to be used as a way to force confessions.
No. And
it's I just, this is nuts.
And Steve Gosney was here earlier, and he said it doesn't matter if this was a civil contempt ex parte meeting. If the information has some, even theoretical validity in this trial, it must be disclosed. And
wasn't the suggestion that it was a confession?
Yeah.
I mean, that's obviously relevant.
Yeah, definitely. And even if it wasn't disclosed in that meeting that he said, I did it, but the information to the court was that he had made a confession, that it doesn't really matter. It's possible exculpatory evidence that must be disclosed to defense. And the judge chose to try to have it unknown to the defense until after the trial. And because he keeps
After
referring
the
to,
trial is insane, right? Like,
yeah, because he's referring to, well, if the appeal court says I'm wrong, I will be prepared to listen to that. And that tells me this judge wants this trial to go to the end and get a conviction. And
it's nuts.
yeah, and I've been covering this trial, this case, for over a year now. I started in mid-May of last year, and it's been so ridiculously stupid. Just the fact that the judge, when in November of 2022, the state said we are ready for trial. January 4th, 2023, they started with the jury selection. During that time, from November 2022 to November 28th, when the actual trial started, the prosecution's case grew from 70 witnesses to 740.
What?
Yeah.
I thought Karen Reed was bad for that.
Yeah. And that was under the year, more or less the 11 months of jury selection. The case grew from 70 witnesses to over 700. Since then, the judge has ordered the prosecution to slim it down. And they did, first down to 400 and now down to 209. And this trial was scheduled for 6 months.
That's a slim trial. Okay.
Yeah. And among these 209 who are so essential, last week they had 2 guys from Hertz Rental Cars, the clerk and his manager, for 5 hours talking about how Jeffrey Williams rented 2 cars. That's the slimmed down version of this. I mean, it's so. And my chat and viewers, there's so much to go through about how much this judge has screwed the defense over. And yeah, but now the gauntlet is down, the line is in the sand is drawn. And yeah.
This
But
is it's basically one or the other is going to be in some serious trouble. So
yeah, and I actually don't think the person in most trouble is Mr. Steele. And apparently now more or less every lawyer, defense lawyer who was near the courthouse is in the courtroom now to show support for Mr. Steele. And he is being represented in court by Ashley Merchant, who is the attorney who brought the disqualification case against Fannie Willis. And he's good. And the proceedings in the disqualification case didn't give her justice. I've been watching her in the Georgia Senate committee for the Georgia Senate wants to know what the actual F and how can we plug the holes that allows Fannie Willis to more or less embellish money at this rate. So they're holding a bunch of hearings about it. And so yay me for choosing the Young Thug trial back in May of last year.
You made a good call.
Yeah. I mean, it's been a year of absolute ridiculousness. Have you heard about the pinch and zoom guy? Oh, the pinch and zoom guy. In a pre-trial hearing, they have the Daubert hearing about experts. And up goes who the prosecution wants to have as a forensic video analyst. After cross-examination in the Daubert hearing, we found out that this guy, who is in his late 60s, early 70s, for the past 20 years from Fulton County and other Georgia police departments, have received video with a note that says, we need this part of the video enhanced. So what he does, he plays up to that point, stop, takes a screenshot, puts the screenshot in Photoshop, and does the pinch and zoom. That is all he has done for 20 years. And the prosecution wanted him as a forensic video analyst.
Oh wow. No,
I wish I was joking.
I wish you were too, and I know you're not.
I mean, my 3-year-old niece can do that. But he wasn't accepted as a forensic video analyst. He was accepted as a video enhancing expert.
Wait, what? He was accepted?
Yeah, as a video enhancing expert because he could do the pinch and zoom.
I would have written a decision on that that would have been so scathing that the guy would have had to crawl into a hole and never emerge.
And I can't wait for him to actually take the stand as an expert so I can show that Daubert hearing with him in. It's way back in June or July of last year when I covered those Daubert hearings, and it's yeah. And it's been this ever since. The absolute ridiculousness of the prosecution's case and how the judge helps the prosecution. Every time they have an argument about a piece of evidence, first the prosecution goes up, we need this in because of this and that. The defense says, no, here is case law. And then the judge says, well, I see the case law here. I will give the prosecution 10 minutes to reinforce their argument. And then they reinforce it, and then it's defense again. No, it doesn't apply because this statute and that statute. And then the judge starts to argue against the defense on how that statute should be interpreted. And he more or less makes the prosecution's argument for them. And he's done that since the trial started. It's absolutely ridiculous. And when I talk about this on other streams and stuff, it sounds too ridiculous. I must be exaggerating. I don't think I am. I think I'm downplaying it because I know how ridiculous all of this sounds.
It's like, no, this sounds too crazy, so it couldn't be real.
Yeah. If this was a TV show about courts, it wouldn't survive the cut for that episode because it's too stupid.
Yeah, somebody would be like, no, this is not plausible.
Ooh. Ashley Merchant is now speaking to Judge Glanville. I want to hear this.
Yes.
Let's see here. What's going on? Why isn't... Oh, there it is. Let's see here. That's there, I believe. Oh, wrong button. Yeah, I brought it up. Yeah.
That order, I'll go ahead and sign it, and I'll also make a copy of it as the next court exhibit in order, and we'll e-file it this evening. Okay. All right. At this point in time, who it is that disclosed this information to you?
Yeah, that has been the one question from the judge. He wants to know who disclosed the information that one, they had this ex parte meeting because it was supposed to be a secret. And if it's more than one, who gave the information of what was said in this meeting? And that is what Mr. Steele is refusing to disclose because Rule 1.6 in the Georgia ethics rule of, let's see here, what is State of Georgia Bar Rule 1.6, confidentiality of information. And I read that earlier. I will try to send it over to you. I can send it over.
Unbeknownst to me, Gactyl is here, but they're not being allowed into your courtroom. I presume they're outside. So I'll wait on them to come in.
I'm asking you, sir, because the contempt is for you. It's not to the Georgia Association of Criminal Defense Lawyers.
Well, I didn't call, but.
Okay, and that's,
Let me just finish.
okay.
Because you said to me that you figured out somebody told me this information and you somehow said that it's privilege, which I can't imagine, or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. They brought down lawyers. The lawyers are not allowed into your courtroom.
It's not on.
No, we just,
Or they're not in your courtroom.
we just don't have any space, Mr. Steele. And plus, they're welcome to go to 8H. I mean, I told Sergeant Ingram that we can let in as many as we possibly can, that we'll fill up our benches at this point in time, that won't violate our security protocols, but that 8H is available. And they're
8H then has to have right to counsel because they're here, and I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashley Merchant is here. She's a president.
Okay, all right. We'll let Ms.
Criminal
Merchant in.
defense.
That's fine.
Yeah, Ashley Merchant is the president of the something. So she is the real deal.
Ashley Merchant.
Yeah, Ashley Merchant.
Ashley Merchant, yeah. Right, Ashley Merchant is present.
All right. Ms. Merchant, good to see you as usual. I have told your client, you represent Mr. Steele, is that correct? For the purposes of the contempt, I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, and that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not,
Tell me who snitched. Tell me who told you the information you weren't supposed to find out about until after the trial.
then, as you well know, as a criminal contempt, there's no supersedeas bond, there's no appeal, and I'm going to put him in custody for this.
I have never heard an unappealable punishment.
Oh, I think he might find out that he's wrong on that one.
Yeah, I mean, everything can be appealed. You just turn it down. But if there is, I mean, everything can be appealed. You can appeal death sentences. So why can't you appeal a contempt of court decision? It's
This evening, and
especially when the person who is doing the punishment is the person who decides if he did wrong or not. Because he took it on himself to deny motion of whatevers to, I didn't do anything wrong. Well, how are you the person to do that conclusion? Because I didn't do anything wrong by not disclosing. We had an ex parte meeting with a sworn-in witness in the middle of his testimony, where the information was revealed that he confessed to the murder, which the prosecution is trying to pin on one of the defendants. I mean, whatever could be wrong about not disclosing that? It's not a Brady never existed or exculpatory evidence obligation from the prosecution to disclose. It's almost as that doesn't exist in this courtroom. It's
and And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is, because of the way this information was disclosed, it is troubling to the court and is very, since it was a ex parte communication. We won't get into the merits of everything else that Mr. Steele has proffered and everything else, but
So you're using it
that's
as
the
a
only
means
thing
of
I'm trying to do at this point in
investigation?
time. So
No, that's not appropriate at all. Like, the contempt power is not to be used for you to investigate.
No, I mean, he's been trying to tell the defense attorney, because Mr. Steele's co-attorney says, Mr. Steele is the main lawyer. I cannot provide the defense for Mr. Williams as Mr. Steele can. And if you put Mr. Steele in contempt of court, Mr. Williams does not have adequate defense. In which the court says, well, I think he has, by you, the co-counsel. How is this not blackmail? I mean, judicial blackmail.
It's nuts.
Yeah. But I think the judge have to have painted himself into a corner, because there's no way out from him from here. He already stepped over the line. And yeah,
I think the judge has burned his house down here.
And he recently got re-elected. So it's not like they can vote him away in the fall. He just got re-elected just a month ago, unopposed as chief judge.
There's got to be disciplinary proceedings available, though.
Yeah, but I think that's it, either in the appeals court or the Georgia Supreme Court. So it has to go up there. But so far, this judge has denied interlocutory appeals to be submitted to the higher
Game
court.
on.
Yeah. I mean,
I've asked your client for the last time if he would tell me who it is that disclosed that information.
Judge, can you come up to the microphone? Sorry.
Please.
Where would you like this?
Microphone, it'll pick up, madam.
Thank you so much. Just for the record, Ashley.
Which one?
It'll turn green. Yeah, it'll turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great. Thank you. Judge, just for the record, is the criminal contempt, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. That I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So.
Yeah, the information was that Woody confessed to the murder that the prosecution is trying to pin to one of the defendants. And he's actually saying, yeah, that is correct. And that him and the prosecution chose to not disclose it.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list and notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot.
I've never heard of a contempt, because even if they hold the hearing later to justify the criminal contempt, I've never heard no hearing
this is wild.
contempt. Never heard of it. And I mean, I'm not US based, and I came into the LawTube thingy a year and a half ago. But when it comes to Atlanta and Georgia, I mean, I read through that damn RICO Act, and it's so broad and so vague. It's so broad and so vague that the connection between the crime, the person who committed the crime, and the alleged gang member can be spoken and unspoken, according to statute. It's that vague. If you nod to somebody, you can be a part of a RICO charge in Georgia, more or less.
Told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
Well, and
Okay.
Judge, just for the record, it's, that's direct. So what you're holding him in is in direct criminal contempt.
yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. It doesn't require recusal. You actually have to sua sponte send it to another judge because you're a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it
'cause
is
I- 'cause-
Henry McClarty. It's 152 Georgia App 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215.
2-1.
By the way, I don't think he can rely on the prosecution here. If he wants somebody to talk for him, it's either himself representing himself or he needs to get a lawyer. Oh,
5.
Georgia App
Georgia App.
372.
Okay.
Also 215 Georgia App 349.
Okay.
That's Adams and Hasty.
All right. Let me take a look at those.
oh, this is beautiful.
You have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding. So most of the cases are a little bit older. But I do have other cases.
Oh, the moment the judge started talking about criminal contempt against Mrs. Steele, I think people say, what now? And then lawyers started working.
I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I have space allocations, as I told you. So
No,
you
it's
can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H and they can certainly watch the proceedings from there.
Okay. And Judge, for security purposes, they're all attorneys. They're all members of the bar. I can give you all their
They
names.
still would have to be searched and still would have to be subject to the court's protocols.
And also, there's room in the jury box and then there's room in the courtroom. So we would ask that they be
I
allowed to.
don't want them in my jury box, okay? No.
I understand.
She's just getting him to like continue to paper the file.
Yeah.
May one additional attorney come in, then Alex Susser. And we're here on behalf of Gactel for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So can he come in as another attorney co-counsel?
Yeah, certainly may, sure.
Great. Alex Susser. Alex Susser.
Suddenly sounds
Thank you,
so
Judge.
weak.
Henry Adams, it has two issues. One is the motion for disqualification. Okay. And that's,
A ponytail lawyer.
and I think the judge went ahead and did some other things that caused there to be that issue presented. So I don't.
Oh,
I'm gonna take a
no.
look at the other case. That was Henry Adams. That was 215 Georgia 372. I'm gonna
Yes.
look at the other case just a second.
And there's several others when you're ready.
Oh. Yeah, this is wild.
This judge is going to end up like
I've been saying it for a while. He should not only be disbarred. The only time he should be allowed to enter the courtroom is when he is the defendant. And the judicial immunity is extremely strong, but it's not absolute. And there is a movement against this immunity thing. And this might just be the case they wanted to bring that up again higher up. Hey! Hey, Valhalla. Good to see you.
Yes, it may be one I have too.
Everybody works for money. It has nothing to do with morals. Everybody works for money.
yeah, it's like you got to eat.
Yeah. If I had a choice, I wouldn't represent a third of the workers I represent and have represented for the past 30 years. But I do labor law. That's my thing. And I'm contracted by a union. I don't choose my clients. I get cases. Here you go. Oh, crap.
You're like, oh, this is dog shit.
Yeah. Especially when you see one for the third time and you know he lied the 2 previous times. That's a fun thing. But
Hasty's conduct didn't rise to a level in this system warrant summary contempt by the court. That's the difference with Hasty than in this particular case. So
And
I distinguish your 2 cases that you've given me thus far.
oh, those were only the initial 2. I had a couple others.
Okay, go ahead.
As well. Yes. So Ramirez versus
He's gonna
State, it's
distinguish on thin
279, Georgia
bases for every
13,
one of them.
2005. It also,
You said 279 Georgia what? I'm sorry?
Georgia 13.
Georgia 13?
It's a 2005 case.
All right.
And it defines direct contempt and explains that it must actually interfere with the proceedings to be direct. There's also a couple other cases on that.
And now he's going to say, well, it did interfere with the proceedings because I need
Steven,
to know
you all
what's
are
happening.
covering under.
yeah,
Let me see.
that's a nice
sorry, Judge?
circular argument.
Just a second. Pardon me.
Well, he's like, let me figure out you can see that he's trying to figure out why to reject it.
Yeah. But he has to reject it because if he doesn't, he is a witness.
Yep.
And he definitely don't want to be a witness and sworn in about what was said in that ex parte hearing.
Well,
meeting.
and the other thing is if he's a witness, it's got to go to another judge, and the other judge is not going to back his play here.
No. When if they send this over to a new jurisdiction, the district attorney there says, this is dog crap. I'm throwing this out. And Fannie Willis definitely don't want to do that because she has staked her career on RICO trials. Or paying men to have sex with her. Oh, did I say that out loud? Oh, sorry. Oh yeah, Judge Glanville has a support dog because Judge Glanville has PTSD from his service in Afghanistan.
I mean, I'm not going to judge that.
He was the brigadier general for the judicial system that was put in place in Afghanistan that is now used by the Taliban to prosecute women and children.
I mean, that's also not really his fault there.
Yeah. Yeah, but he could have taken the blueprints out when they left, and he didn't.
The contempt is directed. Trial court has the power, after conforting the contempt door to opportunity to speak and in his own behalf, announce punishment summarily and without further notice or hearing. I already did that, Mr. Steele. He's already told me, I already gave him the opportunity to do that. So,
That's not a hearing.
we had that conversation this morning already. So,
And Judge, so there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you, because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. And as to how that information was disclosed, that's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were ex parte,
he does. I'm not saying anything, but but he's kind of put himself in the particular position he's in.
Kind of.
No, Judge, I don't agree. I believe that
I'm gonna disagree with you. Okay.
I believe that the court has put him in that position.
No.
He cannot be held in the law states, McClarity, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder, obstruct the orderly process of the administration of justice. The preservation of order and decorum in the court is exempt from due process requirements of notice and hearing. That's even Moody. It goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there, because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that, because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you aren't part of them, by nature.
Okay. Well,
you have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. But here's the thing. You got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways.
He's mole hunting.
Eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant,
he got information he was not supposed to have. I mean, if that information is possibly exculpatory and you are actively hindering that exculpatory evidence to be disclosed to the defense, seriously?
It's basically you're just running an unfair trial at that point.
Yeah. And
like, why not just skip the middle step and just go directly to conviction?
Yeah, just let the jury out, declare that this is a bench trial, and convict them. And
just declare it's not even a trial at all. It's just like, direct conviction.
Yeah.
Opinion, I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
Yes, Judge, there's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the...
Yeah, he's a witness and the judge. He can't be both.
Contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let an appellate court decide that.
So, you.
No, we'll file a notice of appeal.
Yeah, and
going.
that is his standard. I will let the appeal court decide that.
Oh, don't like that at all.
No, but that is his standard. It's not the first time he said that. If the appeals court believes I did wrong, it's up to them to tell it to me, and I will listen to them. That is his standard defense. I will let that go to the appeals court. Okay, then they will follow a notice of appeal. But he claimed earlier and several times that this contempt of court that he has imposed on Mr. Steele cannot be appealed in open court, on the record.
That's insane.
I mean, I've been screaming from the rooftops for a year now that this judge is unfit for his position. And
well,
most people, and if you don't follow the trial, oh, it's exaggerating, it's hyperbole, it is.
He's giving you some evidence.
Yeah,
he's working to prove your case there.
Yep. Now it's good to be right. But on the other hand,
Is it really?
Yeah, I don't want to be right because how many more have he done this to that we don't know about?
That's kind of the thing.
Yeah. How many appeals will there be when people learn that, oh, he couldn't do that? Appeal.
Well, I mean, this Steele is willing to stand up to him. So,
and he has done that before. Steve, you're back.
Hey, how's it going? Just thought I'd pop back in and see what's happening.
Oh, Miss Merchant is teaching the judge, this is the actual law. This is the actual rules. These are the statutes. And his answer, after not being able to answer the final few things, is, I let the appeal courts decide that.
See, teaching implies that he's learning. And I don't think that's actually going on.
Yeah.
Yeah, this is what I was saying. So they actually they have people in the back that are working on this stuff. So they filed, what did they file here? Because
they filed a motion to set aside contempt. they have and they have a few motions ongoing, but in this motion, to let's see here, where is it? Yeah, number 10 here. Hold on while I show it. Thus, the court has imposed an illegal and inherently inconsistent punishment for this criminal contempt. Moreover, the court has involved himself in this proceeding, and thus the court must recuse and allow these proceedings to be handled by a separate
Yeah,
court.
so I thought they would do this tomorrow morning, but they did it immediately. So they're basically moving to disqualify the judge, which will be an interlocutory appeal.
Yeah, and just a few minutes ago, that was her argument. You held an ex parte meeting, which means you are a witness to that meeting. You can't be both the witness in that meeting and then hold Mr. Steele in contempt as a judge for revealing information that meeting took place.
Yeah, and Ronco, what if, I mean, have you ever seen anything quite like this in a case?
God, no. I had a judge who I thought might try to hold me in contempt. And he didn't end up doing it. So like that was he tried to get me to like basically to talk about my client's performance at a at drug treatment, and I was like, yeah, I can't do that. I can't go supervise my client's drug treatment and then report. Like that's just not, that makes no sense. That's not going to be a thing. Yeah.
Well, it's crazy because not only is the contempt action really kind of the nuclear weapon, which is to me a very blunt and big bomb to be dropping at on this thing. You know, it's like, what is it? In fact, what you're getting is a reaction because the judge got caught doing something he shouldn't, and he's reacting. And this is the problem. Really, the judge should be disqualified, and it should be a mistrial. Because have you ever heard, and I don't know, you're a Canadian lawyer, because I'm not sure the rules up there, but for the judge and the prosecutor to meet with a witness who's on the stand testifying and not include the defense attorney and then not disclose it, it's crazy. I've never heard of that.
It's insane. I just cannot envision.
Yeah. And his excuse is, well, this was regarding this witness civil contempt.
That's just words. That's just garbage words of weasel words. It's like, I'm applying the full faith and credit. It's just jargon to confuse things. The fact is, this judge and this prosecutor met ex parte with a witness who was on the stand and did not include the defense attorney. I mean, it's unbelievable. To me, that's debenchment type stuff.
Oh, I agree. Like from what we've seen here, he should not. Like this is just nuts.
Yeah, and I hate to repeat myself. No, I don't. But the only time this judge should be allowed back into a courtroom after this is if he is the defendant.
Well, the thing is I'd like to know what the Georgia bar and how the judicial, because this sort of thing should go up to the bar. This to me is bar type stuff that really should look into. JQC, Judicial Qualification Commission in Florida. The judge involving himself like this in the prosecution of the case, really, I think it's really out of line. The judge is supposed to be a referee, an umpire. Yeah. And it's kind of like in a boxing match that referees like, okay, boxers go at it and they're fighting, and then ding, 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 and people go to the corners, and then the referee goes over to one of the fighters that says, hey, I see he's lowering his left. You should hit him. You should hit him with the right when he does that, right? I mean, it's like you're coaching the guy, right? What do you?
I mean, it's not even coaching. It's just they're straight up. He's gotten involved. It's more like he just steps in and like takes a swing at one of the boxers.
You're right. That's exactly right. Very good. I like that, using the boxing analogy. So yeah, I've never.
Andrea would be proud.
Yeah, I've never seen that. I mean, and I've seen a lot of crazy shenanigans, but it's obvious you just don't talk to witnesses once they're sworn in. And you don't ex parte people. I actually had a prosecutor, judge, and a judge ex parte me on a very nasty case. But to tamper with a witness who's on the bench, on the stand, that is very, because here's the defense here. And of course, defense attorneys always think the worst, right? But why is this guy going from I'm taking the fifth and I'm not testifying and I'm refusing to testify to all of a sudden, sure, I'm ready to testify? What happened at that meeting? Something happened to make that change. And we think that the prosecutor came in and said, tell you what, you give us what we want, and we'll give you a really good deal, right? That's what happened. How do you know if that happened or not? Well, and the judge is in on the meeting and the defense attorney isn't? It's crazy. That's crazy stuff.
This is just bizarre to me.
I just remembered Fannie Willis, who is the mastermind behind this Foster clock. There is one person missing from this entire indictment, and that is he is self-confessed one of the founders of the YSL gang, and that is YSL Monroe. He is completely missing from this case because a few years ago, Fannie Willis was YSL Monroe's defense attorney, which leads me to believe that most of the things that is learned for the basis of this entire RICO trial, she learned as his defense attorney. That's my theory. And that is why he's not even mentioned in the indictment, even though he was one of the founders of YSL.
Yeah, it sounds to me like they got big problems up there in Fulton County, and I don't know, what is the answer? Can you give us a Canadian perspective? Because you get these jurisdictions that are lawless, and it can cause a lot of damage to the country.
Mm-hmm.
And what's the solution?
More coverage. This is happening in front of a world audience right now, and this is going viral all over TikTok, YouTube's, whatever else there is. This moment in this trial is going viral, and there will be quite a few attorneys going in. I seen in the chat that what's her name? The Natalie lawyer chick is going bananas over this. I think I hope EDB takes this up. I would assume on Friday that Rob might have a section about this.
Oh, I'm definitely going to talk about it a bit.
Yeah,
it's nuts.
Yeah, I'm fairly new to U.S. law. Been doing this for a year and a half, but I've been practicing law for over 30 years. I do have some foundation in understanding law, and this is unheard of. But let's keep listening to Miss Merchant. Miss Merchant is a really good lawyer.
Okay.
And we need to have the order reduced in writing as well.
I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has in fact or has filed, and I will note this as part for the record in this case. He's filed a motion to set aside the contempt. He's filed a motion for a superseded bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, grant him a bond on that issue.
You don't get a superseded bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in,
Just the case law on that is in Ray Hughes.
hold on.
I think the judge is over his head. That's what I'm
Oh,
saying.
he is.
Yeah.
They came
Because
in with
now
all
it's-
all of these. What I think is because he's threatened this in the past, they had all
Yeah.
of this ready to go. They were ready and and he is now playing catch up. He's doing his research, on his back foot. Yeah.
He is now doing what he has been forcing the defense to do for months. Is the prosecution brings up something which is completely new. Oh, it's in discovery. Yeah, but you need to disclose what in the discovery you are supposed to use in trial. And the judge is satisfied with, well, how long have you had this information? Well, it was in the discovery, which is terabytes of data.
Yeah. Let's see what goes. Let's hear some more here.
Yeah, but Judge Glanville, he has painted himself into a corner because he
The
can't.
superseded bond requirement does not apply in the contempt in the presence of the court during the progress of a proceeding, OCGA 5-6-13 Bravo. So you don't get a
Does not
supersedious
require.
on that, on a criminal contempt. Respectfully.
He's so impressed with his
So
self.
Judge, just to clarify.
A little humility go a long way.
It's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge, and that's the reason I'm asking is because the N. Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeals 66,
More receipts.
lays out the distinction, as does the Ramirez case.
There's a case that in fact I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Which is, I think I'm addressing a slightly different point of
It
law.
is, hold on. Hold on, sir. One second. Give you two cases. One is
And you can see he's researching them right now.
it's Untema. It's a UNTEMA versus Smith, and that's 371 Georgia Appeals 19. Which was decided March the 12th of this year. It covers the differences between the types of contempt. And then there's another case that I'd invite your attention to.
Thank you, Matt.
And that is
The
in
purpose of
the,
criminal contempt is punishment. The
Cyberson,
purpose of civil
it's
contempt is compliance.
SYPERTSON.
And what the judge is trying to do is make Attorney
Make them
Steele
comply.
compliant.
But the thing is, you can't make them compliant with just anything. It's got to be legitimate purposes.
Yeah.
And
the
revealing a confidential source of information, I don't know. That's outside the purview. And why is that relevant either? He's off on a tear that has nothing to do with the case. Now this is terrible courtroom management because the judge is all getting all personally involved in these bickering fights with the defense attorneys, and it has nothing to do with the case. He's trying to force compliance on something that he got caught doing something he shouldn't, which is ex parting a witness without the defense. The defense calls him on it, and he gets mad and holds the defense attorneys in contempt.
He's like, "How dare you catch me on?" Yeah.
Yeah. As Noku said, Steele said it violates 1.6 of the. But that is, let's see here. I'll have it here. Rule 1.6 states, A lawyer shall maintain in confidence all information gained in the professional relationship with the client, including information which the client has requested to be held inviolate or the disclosure of which would be embarrassing or would likely be detrimental to the client unless the client gives informed consent, except for disclosures that are implied authorized in order to carry out the representation or are required by these rules or other law or by order of the court. But as with everything, comments. There are written comments to the rule which allows which helps the interpretation. And here it is, comment 5. The principle of confidentiality is given effect in two related bodies of law: the attorney-client privilege, which includes the work product doctrine, in the law of evidence, and the rule of confidentiality established in professional ethics. This is highlighted. The attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. The rule of client-lawyer confidentiality applies in situations other than those where evidence is sought from the lawyer through compulsion of law. Rule 1.6 applies not merely to matters communicated in confidence by the client, but also in all information gained in the professional relationship, whatever its source. A lawyer may not disclose such information except as authorized or required by Georgia rules of professional conduct or other law. And this is where I believe the judge made a huge mistake, because he has so far not applied any law or statute to his decision.
Tyrone's saying we should play the video because we're jumping the gun. The attorneys are ahead of us. So let's see what they say.
Okay.
And that is 368 Georgia Appeals, Georgia App, I should say 865. And that was decided July 31st of last year.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond. I'm not
going to grant a supersedious.
And so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies. Criminal is where you get to impose a sentence, maximum 20 days and $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he when he tells me
you're using civil
conversation was, I didn't ask what, but he tells me that, then I can certainly he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
And that's respectfully, I would point you to In Re Hughes, which stands for the same point of law. Civil contempts impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt, and that is you do
it doesn't. Criminal contempt is just a punishment.
Yeah.
Yeah, I want to do away with this pesky thing called Constitution and rights, and the fact that a defense attorney has a right to defend themselves against a crazy ass judge.
Yeah, I mean, he's using the civil definition to apply a criminal contempt. You have to choose. I mean,
This is ridiculous. This is an abomination. But this is sad. I mean, our courtrooms. I will say that really we are in big trouble in this country. We have courtrooms running like this.
I mean, this judge is basically just saying, I get to hold you in custody and screw due process, screw the law.
I'm a black robe tyrant. I can do whatever I want. I am the law. You can't answer me. You can't question me. Nothing.
What is happening is the judge stepping outside of his role as a gatekeeper and into the role of both a prosecutor, a witness, and the judge. He is judge, jury, executioner. The exact reason why that is in history. We stopped doing that a few hundred years ago in some cases, having the judge, jury, and executioner in one person. But this is what the judge is doing. He puts himself in the place of judge, jury, executioner, and a witness.
He should be in the place of accused at this point.
Yeah. As a witness and possibly a defendant. This trial and this judge will put that judicial immunity at risk. And there is already motions, not in this trial, but motions overall to get rid of much of that immunity. Because I do believe that the immunity, if I remember correctly, it was that Steve Lado up in Michigan who said there is actually no statute to rest the immunity on. It was a suggestion that then just became a rule of immunity. I don't know exactly.
Let's see how much further this judge gets with this, because let's see if he actually holds him in contempt.
Oh, he's in custody right now.
Yeah,
I didn't ask him to do
he
anything.
He has been in custody since
I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who the person.
That's also the privilege.
Okay, I'm sorry.
Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about this a second, okay? I'm gonna take 5 minutes out, I'm gonna think about it.
Thank you.
Okay, all right. So we'll be in recess about 5 minutes.
That is a smart move right there.
Yeah.
That's what he should have done a long time ago. When you're over your head, take a break, consult with your other judges back there, your JA, your legal research assistants, and get it.
Oh, if there's another judge back there who's been watching this, then I suspect that what they're going to say is, what the hell are you doing?
Get yourself out of it.
Uncontempt
him, exactly.
I mean, at this point, what I would say is, like, you got to release him and you got to grant the mistrial. That's it.
Yes.
That's all you've got.
Oh, it's just disaster, Bill.
Yeah, I hope in the background Judge McAfee is there. He is the one who did the Fannie Willis disqualification hearings and is the judge in the Trump case. So you can't really accuse him of being, because he is a RICO judge as well. So he is probably the person he should call right now in this break. Judge McAfee.
Yeah, this is definitely the time
I done
to
fucked
phone
up.
a friend.
Or do a 50-50 or ask the audience. No, don't ask the audience. We are the audience here. Don't ask us, Judge. We will say words. We are past 4 hours. We can say words. But I said words after 12 minutes. So.
And how'd that work out for you?
Well, I'm still green, I think. Let's see here. Yeah,
You see,
um,
it's
I always
Mao's
turn
want-
on monetization after the.
yeah, I know. It fluctuates between yellow and green depending on where in the stream I am. And after this stream, I will definitely be in the yellow.
I always
that's,
turn it on afterwards, but not during, because I get people complaining that YouTube likes too many ads.
Yeah, but I don't. When I put that on, I insert mid-roll ads manually, and since I don't, no ads, or at least it shouldn't be. But it sometimes happens anyway.
Yeah, what is it? Somebody said they put Mad says they already put so many months. How many months is trial? A mistrial is a tall order. I get it. I get
mistrial is a tall order, but it's necessary
it's
at this
necessary
point.
to preserve.
I don't
justice.
see a way around a mistrial at this
I don't
stage.
either.
Those 5 minutes turned out to be 20
or more.
Is he still not back?
Wow.
How do you not do a mistrial here?
Yeah, it's a mistrial. I mean, it's because the judge is it's impossibly biased. I would move, and it has. I guess in the motion they asked to disqualify the judge, which the judge should be disqualified. And when the judge is disqualified, you can't have another successor judge come in the middle of a trial and pick it up. It's a mistrial.
No, it's 100% a mistrial.
Yeah, this is a half an hour, 5-minute break, by the way, so far.
Well, he's getting.
I mean, I'm not going to give him grief for taking some time to think.
No,
because 100% he should be.
He's dug himself such a deep hole that I don't think there's a way out of it. But
I mean, the way out of it is basically, come back up in China and,
Yeah, I mean, as Ian said, where is the way out? The only way out is him releasing him and then act as nothing happened.
But see, the problem though,
that's not even the way out, because
but now you still have the problem of the judge involved with an ex parte communication with a witness who's on the stand with the prosecutor and excluding the defense. The issue is still right front and center.
Yeah,
and that the judge is now a witness.
Yeah.
And that is just an unbreak. There's
no
broken.
saving this.
I don't think you can save that. They've got to disclose that. He's got to grant a mistrial, let the defense look at it. I don't know, but they could plunge ahead, but it's a broken trial. And of course, you got a rubber stamp on appeal. It's possible you could plow through the mistake and forget the law, but at this point forward, the law is not being respected.
Oh, absolutely. I mean, this is just this is a nightmare.
And the judge is way over his head. I mean, this is a big, hairy trial, and you need your best judge on the stand. This judge is not in control of his courtroom. He doesn't know what he's doing. He's winging it. He's used to pushing his weight around and having defense attorneys kiss his ring. And when they stand up to him, he doesn't know how to deal with it because he doesn't have his foundation set. You need to have an old judge who's got his foundation straight. Hey, Fiery Red Podcast, man, good to see you. Fiery Red.
I still ban him from super chatting or anything because we didn't get him the funds for him to try to pay it back.
Yes, that's right.
The rest of you, though, I don't mind. Just saying, I really don't mind. There is currently 400 of you here.
Yeah, we had a nice interview. I don't know if you saw the interview I had with Fiery Red Podcast on my Rumble channel, talking about all his issues that he's dealing with. So it was really good to kind of get to know him.
How many times the states get to rebut a defense motion?
You're supposed to get one round. See, the other thing is this judge is bickering. It's like he's bickering. He's going back and he's advocating. He's really out of line.
What's the education to be a judge in the U.S.? Well, usually you have to have a law degree, but in some rural areas of the United States, you don't have to have a law degree. You can be voted in as a judge.
Well, and also you have to have 5 years of good standing with the bar. So a law degree, you have to have a practicing bar license and 5 years of practice and we actually, that issue is currently in the court in my jurisdiction because we have a judge who got booted off the bench for misconduct, who is now running for judge to re-elect.
Oh,
But because he was booted off the bench and he got sanctioned by the bar, he got disqualified at the trial level by his opponent, who's the sitting judge who replaced him, because he does not have 5 years of good standing with the bar. And now that's on appeal. So I happen to know this answer, which is like a local judge.
Nice.
Yeah, but I heard that from, I don't remember who I was. If it might have been Sean. There are rural areas where you can get elected judge without, and then have this 4-week education on how to be a judge, more or less.
Some places don't have strict rules on that. So.
Yeah.
Well, interestingly, the U.S. Supreme Court, you do not have to be a member of the bar.
Oh. Sure.
Do you have to be an American citizen?
I'm not sure about that.
Runkle for U.S. Supreme Court Justice.
Yeah.
Move south of the border and apply. I will endorse it. I don't
think they allow elves on the route.
Well, that rule's got to get changed.
Yeah.
That's blatant racial discrimination.
Right. Yes. Rights for elves.
Exactly.
It's an elf.
So we're on break, huh? So
Walmart Gandalf.
My wife is cooking dinner. I can smell it wafting. I just wanted to come back and say I hadn't forgot about you, and that I wanted to catch up and see what was happening. So what's the summary for Ghazni so I can go eat dinner?
Situation normal, all fucked up.
The snafu. Yeah.
Yeah, and here's the thing. It is 1 a.m. and my alarm goes off at 4:30 a.m.
Why do you have to wake up at 4:30 a.m.?
Because I have a farm and I need to do the rounds on the farm to check all locks and everything. And then breakfast, and then...
In case, like, the cows are escaping?
In case there's a burglary, because even though I live rurally, I'm not that far from the nearest town. And sometimes they choose to go out here because I have farm tools, and farm tools are made of metal, and you can sell scrap metal. Sadly.
Well, that's lovely.
Yeah. Woohoo. Farming. So, Ian, if you are doing some commentary on this, you can start a stream and I will redirect over.
I will. My thing is at 8:30 that I'll be 8:30 Eastern.
Okay, so
I'm going to do some limited commentary.
Yeah.
At this point, because
So
it's mostly about
and a
Karen Reed, but I may
Okay.
end up doing something tomorrow, going into more detail on this one because there's no Karen Reed tomorrow, so I may end up doing. I got to figure it out.
All right, I'll have to check here because I don't know when he's coming back. Who else is on now? Let's see here.
I think Emily D. Baker might be.
EDB is... I don't see her being... Huh.
I don't know if she accepts redirects or what.
Yeah, let's see here. EDB is not live.
Okay.
She stopped streaming 9 minutes ago. Let's see, I have... Oh, the lead attorney. He is local for Georgia. For Atlanta, even.
He does.
So let's see here. Copy. And he has AV to the 7th power on. Yep. Let's see here. Boom.
You know who I'd like to see is Southern.
And he doesn't allow redirects.
Isn't Southern Law Georgia lawyer?
Southern Law is
Steve of Southern Law. Is he streaming?
Do they even have law in Georgia these days? Like, I'm starting to wonder.
Yeah, I don't know. Theoretically, right? At least. Boy, this is a mess. So he's offline, right? I don't know. This guy,
Ooh,
this judge
let's
is
see
dug
here.
himself a hole. That's all we know.
Phil is live. Inside the Law.
Okay.
Benefit of the
And
doubt.
I think he is also from Georgia, if I'm not mistaken. Let's check here. And he doesn't allow reader, of course. Sean
Jenny Graham
potentially
says
criminal.
Natalie Lawyer Chick is doing this also.
Natalie Lawyer.
All right. Well, I will let you go.
Yeah.
'Cause- Oh wait, is he coming back or did they terminate the stream?
No, it's still ongoing.
Well, then maybe I'll stick around. I'm
Let's see
tinkering with stuff here.
Natalie
No
Lawyer.
case law
Yep, Natalie Lawyer
to show that that
is
case is no
doing
longer
this
good.
as well,
It hasn't been
because I need
overturned or
at
anything
least
like that.
a
And then the
couple
court goes,
hours of
do you have
time.
anything more recent on this?
Let's see if she allows redirect. Of course she doesn't. Nobody allows redirects. What's going on here?
No.
I'll just post the link to Natalie Loyashik. And
Okay. Well, hey, man, good to see you, Ian. Good to see you. I'd say we're packing. I want to do a stream with Ian and me on talking board gaming sometime.
I'm down. We just got to find a time when I'm not insanely busy because I got to do a stream, but I also tonight have to finish up written submissions about a vexatious litigant who wants to kill me.
Oh, those are fun.
Yeah, he the police have said that he's like a threat to my safety. So I'm going to have some opinions about about what the court does to restrict him. So I got to finish that up. That's fun. That's just me for myself.
Yay. It's why gaming is so much more fun because you can just like.
Are you doing self-representation, Ian?
Sort of. I guess it's self-representation. I'm sort of on a file that isn't really about me, but basically because this guy is such a jerk, the court said anybody in the world who has a reason to have an issue with this, with these proceedings, come explain, come make submissions. So I was like, well, now that he's threatening to kill me and making complaints to YouTube and false complaints to the police and all of that, now I've got some opinions to say, like, hey, maybe this guy shouldn't be able to do all that stuff. So,
okay, I can redirect to potentially criminal Sean, who is also doing this.
Excellent.
So, okay, excellent. We found somebody, so I can go and take a nap before I get up again. And I will be at work at 6:30 a.m. and then I will be there until I don't know.
We're all gonna just die of exhaustion doing this. That's
Yeah, I'm not following these young folks. This was such a juicy issue. I had to jump in, but
I haven't been following it either. But this one is as you said, this issue is just
unbelievable. This judge. I mean, clearly, this was like warning, Will Robinson. I mean,
this judge is going to stop being a judge if he's not real careful careful
right
at
on
this
the
point.
edge. Yep.
Probably looks like completely abandoning his entire position thus far.
Yeah.
Like just walking in saying, hey guys, I did some thinking about it. I did some research on, the case law. I reviewed the cases. And I don't have the authority to do what I wanted to do. So I am cutting you all loose. Like we're over, we're done.
Or just did the humble thing and said, okay, I'm finding that this is civil contempt, and therefore I'm going to grant a bond and allow an interlocutory appeal or whatever he has to do to get himself out of this corner. But then he's still got to deal with that ex parte stuff. And they need to release the transcript. But see, he's a witness now.
I honestly would just say I've screwed up badly enough that I have to grant the mistrial.
Yeah.
Yeah.
And then he's not a witness anymore.
Right.
Yeah, and if it is a mistrial, then that transcript will automatically be released, and we will all know what happened.
The other fun thing is that if it is a mistrial, I'm sure his next re-election campaign will hinge around how in this massive, massive trial, they ended up with a mistrial.
Yeah, but here's the issue. He just got re-elected for a new term.
But I will
just
say
a month ago.
There's a lot of judges
Yeah,
who
but-
have trouble with this type of trial. It's a big, hairy, multi-jurisdictional, multi-thing. You got good defense attorneys who are challenging everything. So a lot of judges are not competent to handle this. This is their handling. They take pleas, they do little trials, they push their weight around, and they get through it. But this one, you really need your best judge on, and he's clearly not up to the task.
Yeah.
In my humble
Okay. I will return to the. I was planning to do a little bit of a break because it has been so mind-numbingly boring the past 2 months. I was supposed to do the Florida death penalty case, the double murder in Coral County. I don't think I can anymore because this just got really interesting.
Yeah, and you're the guy, man. This was your trial all the way. So
I was gonna say, this is your moment, man. The trial, you've been the only person that I know of who's been focused on this trial since forever. You absolutely
it is me, infamous Sylvia, and somebody called Cadillac Law. It's us three that has been covering this, but I do think I started covering this long before the trial actually started. So
yeah. I'm just gonna say you're the best of them, and we'll move on there.
at least the tallest and most Viking-like.
Yeah,
Yes.
definitely.
Hey, I gotta go too, man.
Yeah.
I'll
Have
see
you,
later.
as a Viking, do you actually have the melee weapons though? I might have you beat on this one.
Yeah, I mean, I have this little beauty. I have.
Oh, my cuckoo's out of reach.
If I have big enough pockets, I have my pocket knife.
There you go. And if you don't, if that's not a pocket knife, then you're wearing the wrong pants. Is basically what it comes down to.
Yeah, and let's just say I don't reveal everything I have at home because it's unnecessary to reveal everything you have at home.
Some of the things I might pull out on a live stream get channels banned. So
yeah.
It's like,
yep.
If I just glance over that way, there's the shotgun.
Yeah, I mean, if somebody starts banging on your door screaming, "I want to kill you," you have the means.
I mean, at that point, it's like game on. Good luck.
Okay. Yeah, I need to make a motion.
All right, you go sleep.
Off iFuck. And thank you for joining, Ian. Thank you to Steve, who has been here twice. And I will see you all back here tomorrow with the rest of this faster clock. See you around, folks. Bye. Let's see. Yeah, this is a good see you around song to play.
Crooked Fanny playing dirty tricks in the courtroom. She always picks, bending the rules. She'd know it, but I won't let her get under my skin. Down in Georgia, where the blues run deep, crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady.
In the courthouse where time stood still, generations pass on the hill. Prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption split tight as it bites. In this endless trial we pay the price.